Where was it? Who sent me the docs? There we go. Thank you. Thank thank you for setting it up. I really appreciate it. What's up, everybody? How's it going? So we got some new documents to look over. Um, I also have been running errands today. Um, I stayed up until like 5 o'clock in the at night last night looking over new equipment and bought some stuff. So I'm gonna unbox some stuff and set it up. I just got it in the mail. Um, Mrs. Derp set up this beautiful office for us and uh, made like a little studio. Um, but yeah, let's have some fun here. Let's get to these documents and stuff. So I'm not entirely sure what was delivered. I bought a new mic stand, stand for my camera, which is my phone. um, and then I bought some like inexpensive in-ear monitors so I could get rid of this headset. Um, and then what else did I get? A light. So I'm not sure what came. Two things came today. And I'm not sure, but yeah, I'll get right to opening it. Let's see what I got. What up, John? Projecting Productions. What's up? Sebastian, Economy, Tequila. How you doing today, Tequila? Not too shoddy. Andrew, what's up? How you doing today? So, check this out. I went and bought some stuff last night because of how generous everybody was on the stream, and I got a new microphone, so you guys don't have to listen to this thing anymore. And that's what showed up today. I got a new microphone, and I think I got a new light, so that I can balance out some of this nonsense. I had no idea what I was doing when I was looking for mics, so honestly, I just went off of YouTube recommendations and bought something that was relatively inexpensive. Um, all I knew is that wanted something XLR and USB. See? Um, but yeah, I'll get to the documents in just a minute. I do want to set this stuff up. Yeah, I'm really excited to hear what Mace has to say because this is the documents. I don't even know how to open this thing. What do I do here? Help! I need an adult. Oh, I'm an idiot. I just opened it this way. So this is the Fifine AM8. I don't know anything about this microphone, to be honest. I'm not, well, as I've said before, I'm not like a streamer. I haven't like until you guys kind of helped me come into it. I have no idea about anything. Oh, new mic hype. So look at this thing though. It looks cool. Um, it's got like the little foam pad, the pop filter, and what people said it has like enough space so it actually gets rid of the pops. It looks like a streamer mic, right? It has the LED, the RGBs. I'm all tech. I got tech RGBs now. Um, yeah, come on in. No, no. Uh, Mrs. Dirt does not want to be on camera. um, Look at it. It's cool looking, huh? But yeah, she kicked Mrs. Derp kicked me out of the office and set up all of this stuff for us. Yeah, more RGB, more better. So and it's USB-C, which is great because I don't have any of the what's it called? Uh, XLR stuff yet. So I will probably end up upgrading to that, but I haven't done that yet. So for now, I'm just going to keep it like this. I do have a low profile mic stand on the way as well, so that it'll stay out of my way. But for now, it's going on this little pedestal, and I'm just going to uh, point it at my face. So let's plug this bad boy in and see how this works. It's not going to be, I don't think it's going to be close. Look, this cord is long as fuck. Hold on. I will plug it in and let's see. Let's get this going. Do I even have any more plugs available back here? Oh, what the hell happened here? Was she climbing on stuff? Hello? Is that working? A little better? Hello. So I can't hear you guys right now. I can't hear anything going on right now, but I can see the chat. Let me pull this over here. How does the mic sound? Sound a lot better? So this is actually perfect timing because I think my headset just broke. If you look at this, I was pointing this at the microphone, but this is how I found it plugged into my computer. It was just hanging out like this. So I'm glad that we got a new microphone today because my headset is like hanging on by a thread. Granted, this thing is like 10 years old, but this thing is hanging on by a thread. But I still need to hear. So I'm going to figure something out here. I wonder if I have some electrical tape. Because I do have... Yeah, I'm honestly just gonna tape this. I need some electrical tape. The USB still connected, but thank you. This hat is actually, it belonged to Mrs. Derp and I stole it. But yeah, does the mic sound a lot better? Yeah, I'm just gonna tape it back together. I think I might have another like Bluetooth headset or something. I'll be right back. Yeah, I don't need a mic. I got the new mic. Is it way better? Okay, yeah, I think OBS has an EQ on it. Yeah, I need to add noise suppression to OBS for sure. Give the old headset away. I also have to look over this documentation. Not right now. That could go over there for now. But yeah, so thanks to the War of the Andrews and Mike and everybody who's been buying supers. This is from you guys. Thank you very much. And then until my in-ear stuff comes, I will have this new Cowan headset. This belongs to my lady. That's Bluetooth. Let's see if I could actually hook this up though. Wait. No. That's not live. There we go. Bit off the old mic. That's actually a pretty decent idea. Let's see here. So how do I... Speakers. I don't want speakers to be the microphone. Oh, I guess I can. I can hook this up. Or no, I'm going to do Bluetooth speakers. Input to new mic, output to Bluetooth headset. It's not a bad idea. Wait, this says connected to voice. I don't want the voice though. Okay. So the frame of my camera is a little sideways. Okay. Let's get all this stuff set. Okay, is it like tilted or... Bobby? Either it's tilted or the wall is uneven. Here, let me, is that a little better? Yeah, Axel, I'll get to it in a little bit. I just I wanted to say thanks because basically this stuff was all bought by bought by all of you guys. So, um, yeah. There we go. Okay, cool. So how's the mic sounding now? Is it too far away or is it too close or um yeah, this is my lady's headset. So what else did I get? Oh, what is this? LED desk bicolor video light studio photography. Oh, this is the light. Sweet. Sweet. There's gain right here, so I can turn it up. Whoa. I don't know what the other button does. Sweet. Check this out. So that you guys got me a light too. I ordered this so I don't look all washed out when the sun goes down. Whoa, my Bluetooth headset's like going crazy. I wonder. Huh. Odd. Oh, I have an idea. Is there a... I'll be right back. Here we go. I wonder if I could do that. Okay. I don't know. Let me see. I'm going to put on Spotify and see if I can hear anything. Nope. What's up, Wilson? So yeah, here's the light for the camera. Because people, it was like I got all grayed out. I think it came with a stand. I hope it came with... Did it not come with a stand? It said it was going to come with a stand. Well, that would suck. Supposed to come with a stand here. It is compatible with the stand. No, not yet, Phantom. Yeah, I don't see anything coming out of it. There's nothing in this box. This box is way too small. It has like a stand thing. I have a tripod, but I'm using it for my phone right now. What up, Bakersfield Gaming? Hey, thanks for all the help earlier today. I appreciate it. So it has... How can I hook this up? Now I gotta buy a stand for it. thing's supposed to be pretty bright, pretty decent. At least according to the YouTubers that recommended it. Or origami the box into a stand? I could just, like, prop it up. I don't know why it showed a picture of it on, like, a clamp stand. It had, like, a picture of a desk clamp stand. Oh, here it is. It's in the other box. Perfect. Here we go. Now I'm playing with fire. What do I do here? What do I do here? Like this? Whoa. Oh, but hold on, I gotta... Whoa. Hold on now. I gotta put the other thing on. The other thing on first. It's a stick! They gave me a stick. Come here. Don't make me get up. I don't want to use my legs like a sucker. Okay. Yeah, it's a desk clamp. I wanted to make sure that I had a desk clamp on it. Basically, yeah. Here we go. Just smack. This thing's pretty deadly. Just freaking smack people with it. Bust some skulls with this thing. That noise is terrifying. It's terrible. Wilson, have fun. I'm gonna make some new videos, like actual videos, not just live streams, about this and the last documents. I'm probably gonna do that. I was gonna do that today, but new docs dropped. And I spent a lot of my time like calling people and stuff today. So my thought process is I'm gonna do one of these guys. No, that stays there. I might hook it up. Where should I put this? Like behind? I have no idea. Thanks for stopping in, Big Skillet. I haven't read the new documents yet. I'm just wanted to do this first because I wanted to test out all the new gear that you guys bought me. Like you guys literally bought this behind. Or behind, you guys bought this last night, so you know, I want you guys to see what you guys like basically instantly see what you guys got me. Was the legs like a sucker? Simpsons. Yeah, using my legs like a sucker. One sucker. Oh. How the fuck? if I point it right at my face, my eyes will hate me? Probably. How do I, which way do I turn this? Okay. Okay. Kitty. Birdie. Why is the RGB all fucked up? Whoa. Hey, I can hear. So I don't think this has like RGB modes or anything. But it does have dimmer. It has a controller too. So it has a controller. My stream is like delayed by a few seconds or something. Weird. There we go. Yeah, this is a controller. I don't think they gave me any batteries though. So I need to get some AAA batteries. There's a Dollar General across the street, so I could go get some batteries that catch on fire. Ooh, it has like a little cookie thing. This guy's? It has like a little clicker. Okay. Wow. Okay. 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 Let's get me back in the frame here. Get these terrible headphones in. So I got a new mic. The camera isn't new. It's my phone. I just bought, so there's an app called iReune webcam. And I bought the app, so it lets me do it in 4K now. So I got, yeah, the new mic. I think the new mic sounds better. Is it, yeah, is the picture good? It should be 4K. I paid the $5 or whatever. Now let me see if I can turn this light off. Buttons on the front and the back. Cookie thing. Oh, there we go. Hey, how's that looking? I have a light. So I thought I was gonna buy two, but then I was like, I'll just keep the overhead light on. Screw it. I'm not rich, so I think one will be fine. And I don't want like a shit ton of light just shining in my face. So go there. So I get the new headset on Sunday, and then I get another desk clamp for my phone, so I don't have to use this stupid tripod on Sunday as well. And then I got a low profile camera arm But now I don't even know if I need it because this setup works pretty fine. Like you guys can't see the mic or anything, and I'm like in frame and stuff. So hold on one second. And you can you guys hear the? So I just turned on Spotify. Can you guys hear the music in the background? How did I get? Am I muted still? Okay, I got to figure out how to mute. There we go. I have no idea how I muted myself. So weird. Whatever, I'll fix that later. Okay, so for my mic filters, now isn't there like an EQ setting I could do on OBS? Somebody said I need to like put like an or like a compressor or something. How's that? Is that a little better? Put some more bass. I could turn up the gain too. Like, tell me if I get too loud. Oh, there we go. Mic sounded fine the way it was. Yeah, tell me the good settings for the OBS, Jay. Picking up a little static. Okay, let me switch the noise or the how's that? Way worse. Okay. Opposite. Okay. I have the better shit. Sounds like we're in a microwave. Can hear the air moving around me. Okay, that sucks. Yes, there is actually news, Leonardo. Um, okay, I turned the gain up and I put a new um let me see something. I turned the fan down. Okay, is that better? So let's see if it was the AC. Let's test that out. Is the static gone? So it was the AC. Leonardo. Um, right. Okay, so the AC, yeah, there has to be a way to um it was yeah, there was for me too. Let me turn that on. Sorry for the pinpoint. I think it might have been the air gap in the window. How's that? Is that better? Just add DC to the AC/DC. Okay, cool. Yeah, so there was I think the sound we were hearing was the hot air going out of the window, and there was a gap between the windowsill and where the AC runs out of the window. It was making like a whooshing sound. Um, and then let me close that out. And then how is the light fine? I think it's on the lowest setting. I can turn it up. Reply. Yeah, so it's a reply to the plate. So Nexon sent in their opposition, and this is IM's this is their IM's response to that. Oh yeah, that's probably what you guys were hearing, this static. Is it back? Because if it is, I'll add a noise gate to the. How many replies back and forth? I think this is the last one that could go out. And then the judge is going to look it over. So the oral argument was requested, but the judge didn't hold an oral argument today. Today was just the first chance that they could do it, and she didn't do it. So let me try to get rid of this static. What would it be? Noise gate? Because I have noise suppression on all the way up. So what up, my name? What up, Vibez and Cody? Sean Marvin? Yeah, it's like 90 degrees in here, so I have to have it on. I just wonder if Oh, it just tells my mic to turn off and on at certain levels? Okay. So, remove the noise gate. I wonder if I could equalize it out. NVIDIA broadcast? Let me see if I can get that. Oh, just hit my mic. Download now. Yes. Jay's sponsored by lower my gain a little? Yeah. Is that better? Hello, hello. Testing, testing. Mic check 1 2. Mic check 1 2. Test, test. Okay, maybe I have an idea. Maybe I'll turn down the gain on my mic and then turn up the gain in like the post processing. All we hear is hold the line. Hold the line. Okay, so I have NVIDIA broadcast turned on or downloaded. It's starting out. Hold the line, fellas. Noise removal. Echo room echo removal. So wait, hold on. What did that do? Did that do anything? Worse? Because I have the NVIDIA broadcast. Camera is currently busy. Yeah, of course. Okay. Yeah, I don't know. Um, I'll just do this. I turned the fan down on the AC. Oh, I have an idea. What if I do this? How's that? Is that better? So yeah, I just moved the mic. So it's and made it so it's not facing the AC. So I'll turn that off. Oh, inside of OBS? I did not. So OBS, so the input would be, um, I don't see it. Okay, how's that? Is that better? Here, let me turn the gain back up because my monitoring shows me as being quiet, a little quiet. Turn the gain back up a little bit since the mic's a little bit farther. Yeah, is that gain? Let me make sure. Yeah, the gain is almost maxed. Perfect. 11 out of 10. Is that good? Okay. Sweet. Love isn't always love exactly. Hold the line. Love isn't always on time. Testing, testing. So there we go. Awesome. New mic set up. I got these shitty earbuds in. I got my setting up bands at church. I used to do the audio visual at when I used to go to church a long time ago. I used to do a youth group. Um, and I would set up the audio visual. That was a nightmare. So this document. So now that this is all set up, hey everybody, congratulations, we set it up. Here's the new setup. We have my bobblehead or my Funko Pop of Walter Payton. We have Baby Yoda. We have a little Chicago Bears plushie thing. Painting of Mario that my friend did. All my music stuff. We have an old newspaper from the Beatles. Um, and then I have my PAX West exhibitor badge right here. Because I used to do exhibits for PAX West. That was fun. I got that gamer drip. Uh, but yeah, so this is the new setup. I want to get it like a little bit more colorful, but that's about it. I like it kind of how it is, Lady Derp set this up, so um, it's coming together because of you guys. E-girl makeup, right? I'll be over here doing feet pics in no time. I got them lady feet. Doing a feet cam. I got those high arches, if you know what I mean. Got hooves. Um, but yeah, so this document is Iron Mace's opposition to Nexon's opposition to the dismissal. Yeah, now that we're all set up, let's get right into it. I know that's been like an hour or whatever of setup, but so this was filed today. Note on motion of calendar. So apparently this is what happened today. It says right here, note on motion calendar. So the motion on calendar for today, this is all that happened. Oral argument requested. So they'll probably have the oral. I called the. So for those of you guys who don't know, I called the court administrator today and actually talked to her. I talked to her for a good like half an hour. So Judge Lynn's admin I talked to for about half an hour today, about what's going on with the case and what was filed today. And when I talked to her, she said that um, nothing had been filed at that time. But she did basically affirm that Judge Lynn wasn't going to do any oral arguments today. I asked if Judge Lynn felt like she had enough information, and she said, "Well, I can't exactly disclose that information, but kind of, you know, my assumption was that I was pretty close to being correct." Um, right. Um, and then she confirmed several things. She confirmed that the early case conference is going to happen on the 26th. So I was right about that. Toot my own horn a little bit. I got the day right, like perfect. Um, so all the injunctions and most likely the dismissal and all that stuff will all be wrapped up into those conferences on the 26th. And she sent me the dates, and then I have access to the dates on Pacer now. So um, when those dates update, or if new dates come down the pipeline, I should be updated on. Um, so the information I was able to get today was that injunction and all that stuff is going to be happening on the 26th. That's most likely going to, as far as what I could get from the admin, that's what the uh, as far what I could get from the admin was basically the 26th is the injunction. The dismissal is probably going to happen on the 26th. Not probably going to happen, but going to be decided upon. Um, I did ask if the oral arguments would be made public, and that's entirely up to the defendants, the plaintiff, and the court. The state of Washington only releases information that has to be made public, like legally, like federally. Um, so, or if the court wants to make it public, and with the permission of the defendants and uh, plaintiff. So, if they want to make it available, it will be available. That's all she can really say about that. Um, so stuff like certain dates have to be made publicly available. Anything that so her best explanation was Washington will make anything public that goes from documents like this that go from the plaintiff to the court and the defendant, or from the defendant to the court and the plaintiff. So if it's documents being transferred between all three, um, they will be made publicly available. But that doesn't necessarily mean like oral arguments and stuff. It can if they're sending in information like evidence and stuff like this. We should be able to see a lot of the stuff that's in Discovery as well. Um, but yeah, she said like anything. So I'm gonna have to look into federal laws and what the federal laws say about this. But the federal laws are really going to be the deciding factor on it, because that's what they go off of. Yeah, Legacy. We just really started. There was like an hour of setup. Um, I've been trying. I can get access to I could get access to the documents that are on file, but I can't open the documents themselves. I can just see what the titles are and when they're filed. Um, they don't even let like Korean nationals get into those files. You have to be related to the case or related to the court somehow to get those files, unless they make them open to the media, in which case you have to be a member of the media, and I'm none of those things, right? I am in no way related to Korean anything. The closest thing I have is um, my buddy lives over there, and he's got dual citizenship. Um, he was in the army, and his wife is Korean. He was stationed in Korea, and his wife is Korean. And then I have another buddy who's over there right now. But he's a U.S. citizen, so he wouldn't have access to anything like that. But he is like he's a Green Beret, and he helps train special forces in South Korea, uh, in the DMZ, and
teach them DMZ like de-escalation tactics and like all kinds of stuff. Um, but yeah, so I don't know any like lawyers in Korea. I've been trying to get a hold of some, but it's a crapshoot, and I don't speak Korean, so a fantasy Korean citizen, right? Also, what up? What up, tough RPG? So, what up, Screaming Eagle? How you doing today? I hope the new setup looks good. I hope the new mic looks good. I think I might hold off on getting a new camera for a while because this thing's 4K, and I heard through the internet that uh, Samsung and Windows, so Android phones in general, are going to make it so kind of like Apple. So if you connect your phone to USB, it's going to have native um, webcam, and these things have 4K cameras on them. So why would I buy a 4K camera? Like I basically to get better than my phone, I'm going to have to spend like $1,000 on a camera, right? So I think other than like more lights and some more stuff, and then maybe I might switch this over to XLR, the mic. But this is pretty much my setup for now. I got more buddies than the guy from Pawn Stars. You dig the Mario? Yeah, my buddy Jake painted that. He's super good. I'm huge into Mario. Here. I'll uh I'll see if you guys can see this. You guys want feet pics? Here we go. It's feet pics time. But yeah, check it out. I got Mario tattoo on my leg. You guys can probably see that. Mario, and then I got a Goomba on the other side. That one's a little faded, but yeah, my buddy Eric did this years ago, and then he moved to Missouri. He was supposed to finish the whole leg. Banned. Getting banned for the feet pics. Not safe. Not safe for work. Yeah, there are new documents. I haven't even gotten into them yet, so this is perfect timing for everybody. Um, but yeah, so like I just said, this is the uh, defendant's reply to plaintiff's opposition to motion of dismissal on grounds of forum nonconvenience. So this is Iron Mace's response to Nexon's opposition, and this is, you know, note to the motion on the calendar today. So this is what they went over in court today, and they requested oral. They both have requested oral argument at this time. So before I get into it, I do want to answer this question from Driving to the Moon. My my hypothesis on this question is that if the case in the United States gets dismissed, they will probably release early access as soon as they think is feasible or possible. Because what will happen is there's going to be a window of opportunity for Iron Mace to legally uh, release early access without a threat of DMCA, right? Because Iron Mace will not be able, if the case gets dismissed with or without prejudice, because Iron Mace or Nexon would not be able to send a DMCA until they can appeal that lawsuit. So there's going to be a window of opportunity there. And if they release in that window of opportunity legally, there's nothing that Nexon can do about it. So by the time that Nexon appeals the decision and it gets back to the point where Nexon can DMCA them again, the game will have already been released and taken in millions upon millions of dollars. So when it comes to the judge going, and they will have done it legally, like they're not pissing off any judges, except for in Korea. So like the Korean judges might get pissed. But by that time, Iron Mace's injunction in Korea should have been settled or not. So I think if the dismissal happens, they'll release either sometime late this month or sometime in like by like the end of August. So there's going to be like a month-long window that we'll know if they're going to do early access. And I've kind of already said, like, my opinion was that they were going to probably release sometime the end of this month early access after the injunction here. My assumption was that they were going to have an injunction notice in Korea on the 16th, but that's not going to happen, I don't think. So, Ja Rule, my thing is, I tend to, at least for the United States courts, I tend to follow precedent. So what happened with Samsung or Apple versus Samsung and a bunch of other cases like it. Um, so in Apple versus Samsung, Apple had iPhone, right, and Samsung was coming out with Android and all these other phones that were similar to the iPhone, and they were claiming trade secrets were violated, and Samsung had proprietary information from the iPhone. And what ended up happening is Samsung rushed a lot of phones to market and actually sold a shit ton of phones. So when there was a modified injunction that ended up being put in place, um, because there was a modified injunction put in place, Apple had to put up like a $90 million bond or something, like almost $100 million, to shut down the sales, any further sales of that phone, right? So Samsung couldn't sell those smartphones anymore, but Apple had to put up a $90 million bond, and all of the phones that were already released were still getting service. So they didn't have to recall or refund any of those phones, because refunding those phones and recalling them would put the consumer at a huge disadvantage. If that makes sense. So courts, at least in the US, in situations like this, their primary concern is what's legal, obviously, and then their secondary concern is consumer health, consumer safety, right? Um, because they don't want to do, because so say Iron Mace releases early access legally in the United States, completely legally as far as the U.S. is concerned, and they only sell in the U.S. and they sell like $80 million worth of copies of Dark and Darker in the U.S. And then in Korea they shut it down, right? They go, okay, there's an injunction. Um, they're going to have to take into consider, at least in the U.S., if there was say that an injunction went through in the U.S. courts would go, okay, it's been past the return window for Steam. Um, if we take this game away from these consumers that they've already paid for, and Iron Mace can't afford to give the refunds and fight the court case and do all this and to put up the bond or whatever, um, the consumer is now out this money and the product. So usually what they'll do is they'll try to work in some kind of, either the people who already bought it can still play and Iron Mace can only service those servers and they have to stop everything else, or so like basically put a stop exactly where it is and then everybody who's already playing gets to keep playing, or the courts could force Valve, so Steam, to give refunds, which is possible, or what they'll do is they'll let Iron Mace continue selling, but they'll have to put up like a, you know, 80 million, like a $60 million bond or whatever, in case, or whatever the damages to Nexon would be. They have to put up like a $10 million bond to pay out Nexon should Nexon win the case. That's usually the way that kind of stuff plays out. Very rarely will you see like unless somebody's like blatantly breaking the law, there's usually some kind of modified injunction that will benefit both parties. Especially if the damage has already been done, because the trade secrets have already been put out there, because Dark and Darker has already been released. I mean, that's already true. Dark and Darker's already has already been released. It's just not live right now. It's been released 5 times through playtests, so all of the trade secrets and all that stuff is already gone. Like, that's already out there into the world. So that part of it doesn't really matter. Do I think that we'll be playing by the end of July? I think it's possible. I think it really depends on what happens with the dismissal, and then what happens on the 16th in Korea. Or the night is 17th? No, 18th. I don't remember. No, I think it's 19th. 19th in Korea, 26th in the U.S. That's what it is. So 19th in Korea, 26th in the U.S. I got them mixed up. Um, so it's possible. If there's a dismissal or an injunction in Iron Mesa's favor in the United States, it's entirely possible. Um, yeah, and it's the 19th. Andrew, you're right. Oh snap! There's 84 people here. Hello, everybody. Uh, welcome to the newly improved stream. Thanks to Andrew and Andrew. To the battle. Thanks to the battle of the Andrews. Yeah, so it's probably 30 days after the 19th. So like I think August 18th is when we'll most likely know. On or before August 19th, 18th is probably when we're gonna know more about what's going on with Korea. I'm not like 100% like certain on that, but that's just what I've heard. But yeah, let's get into this newly released document. Let me see if this is the only ones that have come out. I'm gonna jump on the court listener real quick. Um, so there's actually a bunch that came out today. Holy snap! So there's one. So there's a main document. So there's a reply filed by Iron Mason. Then there's 1, 2, 3, 4 declarations. Right. So we have a lot of stuff to read. Move my cam to the top left. Okay. Yeah, go grab some snacks. Everybody get comfy. Everybody get settled in. I'm gonna get ready to go here. Um, camera is in a good spot. Do I need to flip it? Do I need to do any of that good stuff? Both Andrews are here. The Battle of the Andrews have bought me a new light, a new camera. I got a light stand and a camera stand on the way, and some sweet in-ear monitors. Top right, more space there. I can make it smaller too if you guys want. Like boop boop beep. And then I could make this a little bit smaller. How's that? Now flip it 180 degrees. Okay, let me open the app. Like that. You guys like it like that? Is that good? No, no. The other 180 degrees? Put 6 o'clock? What, like a flip it upside down? Stand on my head? Uh, you want me to turn it like this? I could turn it 90 degrees. I can do this. Right here. There you go. How's that? Now you can see my titty. Oh, the painting and the round one. Okay. We got more stuff for the setup. Don't be embarrassed. We scared the lady off. Okay, everybody settled in for story time here. Thank you so much, Bagel Rama. I really appreciate it. Yeah, I mean, like less than a month ago, I had 285 subs. It's insane. It's literally insane. And last night was a crazy competition battle of the Andrews. And now I have all this new sweet new gear. Sorry, this this USB port is all up in my business. So John Marvin, well, thank you for watching this stream. I really appreciate it. But are you one? Are you number 1,000, John Marvin? Um, yeah, like honestly, I really appreciate this whole community. I really appreciate all of you guys. Um, and let's get ready for some story time. Let's get into it. I want to read this. I want to get to these documents. So introduction right off the bat, it's pretty spicy. So today amongst us, they were going. I think today was the first opportunity to have oral, what's called an oral argument, where all three of them get together in like a conference and talk about what's going on. And the judge decided that she didn't want to. For some reason, I've speculated already, but I don't want to speculate too much. For some reason, the judge said, "I don't want to do it," and so today, Iron Mace put in their, as like basically their argument. They put in their response to Nexon's opposition, and that's what this is. Thanks, Andrew, for catching them up. But yeah, it's pretty spicy right off the bat too. I've already read like the first page. So Nexon's opposition distorts both the law and the facts, yet still falls short of satisfying Nexon's heavy burden of rebutting the validity of mandatory Korean forum selection clause in its efforts to litigate this case in a forum that has virtually no connection to the parties or their disputes. Nexon's primary contention is that the DMCA precludes application of the forum nonconvenience doctrine. No court has ever even suggested that Congress intended such as a result. To the contrary, courts routinely apply the forum of nonconvenience doctrine in copyright cases, including when DMCA is applied. I spoke about this on the last stream a little bit. And then Nexon then claims, again, without authority, that the DMCA counter notification submitted by Iron Mace serves as a de facto contractual forum selection clause, while at the same time ignoring the actual bargain for forum selection clause requiring this dispute to proceed in Korea. Nexon cannot substitute an explicit mandatory forum selection clause encompassing this dispute for a legal fiction of its own invention. So what they're saying is that they're just making shit up. Iron Mace is calling out Nexon's BS, saying that they're just making shit up, which is, to the best of my knowledge, actually true. Finally, Nexon argues that U.S. litigation involving exclusively Korean-speaking witnesses living in Korea with relevant evidence written in Korean somehow presents no burden. Nexon is wrong, and the private and public interest factors strongly support dismissing this action in favor of Korea. So a lot of this is opinion in this first page. It's spicy opinion, and that's kind of to be expected, but there is some fact here. Right here, this line, this no court has ever even suggested that Congress intended such as a result. That's pretty much a fact. That's just a factual statement. So no court has ever said, there's never, as far as I know, that there's never been a ruling where the DMCA itself supersedes any type of jurisdiction suit or jurisdiction issue. So just because they agreed to one contract, it doesn't automatically void out another, right? There could be two conflicting clauses, but they have to figure out the contractual obligations of both. And the DMCA itself, while it is an agreement to like a jurisdictional agreement, it's also not a contract, as stated right here. And as stated right here, courts have routinely applied forum nonconvenience doctrine in copyright cases, including with the DMCA implicated. So this is all factual. So Nexon is trying to do something that's never been done with how they're trying to throw out this dismissal. The DMC does not preclude dismissal on forum's nonconvenience grounds. Nexon first argues that this court is precluded from even considering forum nonconvenience because Congress has enacted a specific venue provision applicable not to the Copyright Act as a whole, but to a narrow subset of copyright cases involving a foreign defendant who invokes the DMCA counter notification process. Nexon cites no authority for this proposition, which no court has ever accepted, and which Nexon appears to have fabricated out of whole cloth. So what that means is that they're accusing Nexon of obfuscating the truth, muddying the waters, and just making shit up, kind of, to fit their argument. And that is, to the best of my knowledge, true. They have used cases to verify opinion, not fact, in most of their arguments. So Nexon or Iron Mace is basically saying, where you come from, we call that a lie. Lawyers don't call that a lie, though. It's bending the truth. But it's basically lying by omission, right? It's like, yeah, but it's opinion. It's opinion and leaving out very valuable and important information. And that's intentional because they can't get in trouble for it. A lawyer can say, it's my opinion that this and this and this and this, or state things as opinion all day long. And they could just forget to mention important facts. Like, but yeah, it's basically lying. And where everybody else comes from outside of law school, it's basically lying. The problem is that lying in court is something called perjury, and perjury is a crime of intent. They have to intentionally lie, and proving that is very, very difficult, and accusing somebody of perjury is very, very serious. So they go on to say that there is no dispute that by saying the DMCA counter notification procedure to contest Nexon's improper takedown of Dark and Darker from Steam, Iron Mace was required to affirm that it consents to the jurisdiction of any judicial district in which service provider, Valve, may be found. However, so they're citing the actual law, not just a case. However, subsection 52G, 3D is a consent to personal jurisdiction, not venue. See Epic Games Inc. versus Mendez, 17 CV, whatever, at 5. So it goes on to do the court, and then they actually cite the court case. The court has personal jurisdiction over defendant because he submitted a DMCA counter notification and thus has consented to personal jurisdiction here. Crunchyroll Inc. versus Pledge. Sending a DMC counter notification is an affirmative act that constitutes consent to personal jurisdiction, not the jurisdiction of the service provider. And personal jurisdiction in this case would be Korea. Battle mark. So when the game comes out, I plan on being #1 Bard. I'm going to take Ash's throne with the #1 Bard. Only been lurking for a little bit because no dad. We're trying to get dad back here. Setting the bar low. I got the pro strats for the Bard, man. You need the crossbow, the hand crossbow, and a rapier with rapier mastery. It's rad, and especially now that you don't have to use the loot. There we go. So, an acknowledgement that jurisdiction in a given forum is permissible is not tantamount to waiving the right to challenge the forum as inconvenient or inappropriate on any other bias. Correct. I mean, that's an opinion, but in my opinion, that's correct. Just because you acknowledge it right now doesn't mean that you're not going to challenge it later, right? Doesn't mean so. Just because Iron Mace had to acknowledge it, it doesn't mean that they waived their right to dismissal, you know, or trying to get the venue changed. They just had to accept the DMCA because if not, they would have lost. Bard beef, Bard battle. Yeah, let's have a Bard fight when the game comes out. I want to see everybody just playing Bards, smashing each other. I'll be a court reporter afterwards. An acknowledgement. Okay, so yeah. Then they cite a case. The fact that a party manifests consent to jurisdiction in the designated forum does not preclude application of forum nonconvenience doctrine. Also see Heller Finn Inc. versus Riverdale Auto Parts. Consent to jurisdiction provisions do not preclude paragraph, or is that section? Section 1404, paragraph A. Motion to transfer to a more convenient venue. Nexon improperly conflates personal jurisdiction with venue. I said something about that in the last. I didn't say personal jurisdiction, but yeah, in the last slide. Action Embroidery Corp versus Atlantic Embroidery, or Atlanta, one of the two. I hate when they abbreviate like that. The question of a federal court's competence to exercise personal jurisdiction over a defendant is distinct from the question of whether the venue is proper. I accidentally killed my friend last playtest with the Bard. He was opening the door. I put a video up. He was opening a door as a barbarian. I just bonked him in the back. Like, I got the bug where you won't stop smashing. And I just kept smashing. And I accidentally freaking smashed him. Nexon then compounds its error by asserting that Section 512 G3D is a specific venue provision, which it's not. It's a personal jurisdiction provision, as far as I know, which is not very far. I don't know. I don't know enough to cite this specifically, but from what I've read, of what is it, Section 26C or F? I can't remember. No, this is Section 1404. 26C or 26F is the conferences. Nexon analyzes. Whoa. Why is my brain farting? The DMCA to Jones Act of the Federal Employees Liability Act, claiming that they're different things. This is a Federal Employer Liability Act is a workers' rights act, and then Jones Act. I'm not sure what that is. What is the Jones Act? Questions. The Jones Act is a maritime law. Act requires goods shipped between U.S. ports to be transported on ships that are built, owned, and operated by United States citizens or permanent residents. Okay. The Jones Act is Section 27 of the Merchant Marine Act of 1920, that provided for the maintenance of the American merchant marine. So if you're sending goods between U.S. ports, they have to be transported on ships that are built, owned, and operated by United States citizens or permanent residents. Cool. I did not know that. Now you know. Um, Claiming that the counter notification provision is the same as a mandatory statutory venue, provisions that preclude a forum nonconvenience inquiry. See Loya versus Starwood Hotels and Resorts Worldwide. The purpose of a choice of law inquiry in a forum nonconvenience analysis is to determine if the Jones Act or the FELA, with special provisions mandating venue, so venue, not personal jurisdiction, and the United States Courts District would apply, citing Luke versus Sandstrom. However, there is nothing about the counter notification subsequent of the DMCA that indicates that Congress spoke to and rejected the application of forum nonconvenience to a suit arising under the DMCA. So while the forum nonconvenience was, in this specific case that Nexon cited, yes, the forum nonconvenience was dismissed, but they didn't dismiss it because of the DMCA. They dismissed it for other reasons. Indeed, Nexon's claims do not even arise under the DMCA. They arise under Copyright Act more generally. I said that in the last stream too. Copyright Act more generally, with which the Ninth Circuit. So they're calling Nexon out on their bullshit. I love when this happens. I love this. If I could read nothing but this in live streams all the time, I would do that. Would be great. What's that? Being weird. There we go. See Creative Tech Ltd versus Aztec, rejecting arguments that by giving district courts exclusive jurisdiction of U.S. copyright claims over state courts, that Congress implicitly spoke to and rejected applications of forum nonconvenience to suit arising under the Copyright Act. So, yeah, Nexon conflated stuff that was happening under the Copyright Act, not DMCA. They got the two mixed up. Granting forum nonconvenience motion in a copyright infringement case, notwithstanding that at least one of the defendants consented to jurisdiction by submitting a DMCA counter notification. It strains credulity to believe the Congress intended to reject the application of forum nonconvenience, not as to the Copyright Act as a whole, but only to a single subsection applying to counter notifications under the DMCA. Aside from the fact that counter notification subsection is not a venue proposition, let alone a mandatory venue provision, it defies logic to conclude that a tool designed to protect victims of wrongful takedown notices is actually a hidden booby trap, forcing them to defend against bad faith actors in an inconvenient forum. That's all. This is from this sentence is all opinion. Hilarious opinion. Also, boom, roasted. But it's opinion. It's opinion. I love it. Fucking clap back. Fucking do it. I love to see it. Opinion, I don't care if it's opinion. It's still, I love to see it. If it were otherwise, all foreign companies would face the Hobson's choice of either allowing a bad faith takedown notice to stand uncontested, thereby cutting them off from U.S. service providers, or being forced to litigate in an inconvenient forum with no connection to the dispute. I was talking about that in the last stream, where I was saying that all this stuff happened in Korea, and it's kind of like, even if Iron Mace did what Nexon is accusing them of, they committed two very separate crimes in separate places. The Trade Secrets Act stuff actually happened in Korea, so therefore all of that stuff needs to be tried in Korea. But they sold like my example was they stole a TV in Korea and then they sold it in the United States, right? They're breaking a law in Korea with the Trade Secrets Act because they have Trade Secrets Act over there, and that has its own specific punishments and crimes, right? So they should be tried for that in Korea, and then they should be tried for the sales of stolen goods in the United States. Now, Nexon trying to combine these cases is conflating the two issues, but they know that they don't have a strong copyrights case in the United States, and they don't have any Trade Secrets Act case technically in the United States, and they have a weak copyright case. But if they could somehow argue the point of the Trade Secrets Act in the United States, it makes their case stronger because it's easy to just kind of make shit up about trade secrets because in their own employment contract, anything that anyone did while working at Nexon is now a Nexon trade secret. If they wiped their ass on a Sunday and wrote it down, that information is now Nexon trade secrets. So if they told anybody else about that, they're violating Trade Secrets Act. So they're trying to be sneaky as hell, and Iron Mace is calling him out on it, rightfully so. It's like you're making pitch black. It's like if you're making a whistle, a little reed flute with the grass. Yeah, Nexon's a bunch of fuckers. The last sentence before section 3. What's up? So that's also hilarious too, because that's something that I've called out as well. Nexon is now trying to argue that their own employment contract is invalid, which would then invalidate all the trade secrets that they're accusing Nexon or Iron Mace of stealing. Because if their employment contracts are null and void as of them leaving the company, which is what Nexon claimed in their response to Iron Mace's dismissal, that basically means that they don't own Iron Mace's IP like at all, and they don't own any of those trade secrets. As far as I know, and as far as I've heard, that would bring all of the trade secrets that Nexon is claiming that they own would be in question if that contract is now invalidated. So they're trying to argue two sides of the same coin here, and it's kind of biting them in their ass because Iron Mace has some pretty damn good lawyers and is calling them out on the bullshit. I just like to see it because this is the same exact shit that I was saying like last week and the week before. I just love it. This is exactly what I would be saying if I was a lawyer and they hired me. This is exactly what I would be saying. I'd be like, you guys are just fucking around here. I mean, obviously I wouldn't use this flowery language, but I would just be like, you guys are a bunch of dick asses. Stop trying to sandbag us. Yeah, if it were otherwise, all foreign companies would face the Hobson's choice, blah, 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 blah. Being forced to litigate in an inconvenient forum, no connection to the dispute. There's no authority whatsoever for that draconian proposition. That is a baller statement. Contends that the DMCA counter notification submitted by Iron Mace is a de facto forum selection clause. It claims that this implied forum selection clause, which does not exist, trumps the mandatory forum selection clause in the parties' contracts, which does exist. So, it claimed this is. So this first part's opinion, but they're using some factual information in here to bolster because they're claiming that the forum selection clause in the DMCA does not exist, which technically it doesn't. It's not written into the DMCA. But if you're signing off on a contract, then Oh, I missed the first. Following the invented argument about DMCA preclusive effect, Nexon contends that the DMCA counter notification submitted by Iron Mace is a de facto forum selection clause. This is Section 3. Nexon's claims are governed by a Korean forum selection clause. It claims that is implied forum selection clause, which does not exist, trumps a mandatory forum selection clause in the parties' contracts, which does exist. Nexon is wrong on both accounts. So, Section 3, Paragraph A. Thanks, Joe Rule. I appreciate it. The DMC counter notification is not a forum selection provision. Nexon cites no authority for the proposition that a DMCA counter notification is consent to jurisdiction. Its equivalent bargain for forum selection clause, which merits the Atlantic Marine presumption of validity. What happened? Cody, eyeballs. Nexon cites no authority for the proposition that a DMCA counter notification's consent to jurisdictions is equivalent to a bargain for forum selection clause, which merits the Atlantic Marine presumption. Early case conference is the 26th. Thanks, guys. Which merits an Atlantic Marine presumption of validity. Its argument is once again based on the logical fallacy that consent to its jurisdiction is the same as a mandatory contractual venue provision. It's not. First and foremost, so Nexon's entire argument is basically, I use Pacer. I have full access to case files in Pacer. These were sent to me because I was running on errands, and somebody else got to them first. But yeah, I have access to Pacer. Yeah, in the US they are. The TLDR of today is on or before the 26th. I spoke with the court administrator today. So the Honorable Judge Lynn's court admin, I spoke with her today. I called her on the phone. And she confirmed the 26th for the case conferences. So they're going to go over the injunction. They're going to go over dismissal, most likely the dismissal on or before the 26th. But it's most likely, it's like scheduled for the 26th, basically. Something might change and it might happen sooner, but it's scheduled for the 26th as of now. Nothing is really ever set in stone because the courts can change and they could do it earlier, right? They could all parties consent to an earlier conference and they could just do it whenever, but it'll be on or before the 26th. Mostly question and answer on my part. I assumed some things and I tried to get some information about where Judge Lynn was on it. And the admin didn't really budge. Gave like a half answer on one thing about if Judge Lynn has already basically made the decision or not, or has enough information. I should say does Judge Lynn feel like she has enough information to make a decision? And the admin gave out like a kind of, but I'm not allowed to talk about it type of answer. But that's about as much as I got, other than confirmation of dates and stuff. And then I have access to the. Oh, I just told her my name. I was like, hey, this is me. I'm calling for this. Here's the case number. Here's, and then I gave her my Pacer number for her to add documents to my account, or like give me whatever authorization she needs to give me. I don't know how that works. But yeah, now I have access to more dates. Nothing really exciting. The dates were already pretty much listed on one of the court documents anyway. They just weren't confirmed yet. So now I have confirmation. But yeah, its argument is once again based on the logical fallacy that a consent to jurisdiction is the same as a mandatory contractual venue provision. It is not. I was a leader of the Andrews. I was there at the historic Battle of the Andrews, and I demand answers to this court case now. But no, we did talk for like maybe 20, 30 minutes. And we talked about, because she was like, a few people have called me about this today. What the heck is going on? And I was like, yeah, there's like 2 million people that want this game to come out, and we're very interested in the case. And Nexon sucks, basically. And she was like, yeah, I get it. Like, everybody wants this thing, but they feel like the courts are holding them back. And I was like, we don't have any problem with the court. We have a problem with Nexon. And she gave it a good chuckle. And yeah, she asked me where I got my information. I told her that I'm on Pacer, and I have access to some stuff, and we just talked for like 20 minutes, and then I asked her some questions. No, I didn't say that at all. I did ask her if I could record the conversation and stuff, and she said no. I can record it for my own personal use, but I can't distribute it. But yeah, it is not, first and foremost, the counter notification is not a contractual forum selection clause at all. Crunchyroll 2014, submission of a DMCA counter notification is not a contract. A forum selection clause is something bargained for by the parties. It is not a creature of one party consent. So yeah, one party consent doesn't really exist in the United States for most things. For like literally most things in the United States, you can't really do one party consent. The judge, that at least the admin is now. The admin was laughing at me. She seemed like a nice lady. See Atlanta Marine Construction Co. Stewart Oric Inc. Courts should announce and encourage rules that support private parties to negotiate such clauses, even if one accepts Nexon's ipse dixit. What the heck is an ipse dixit? How have I never heard ipse? Sorry, guys, I'm getting distracted by some of these terms that I've never heard before. Ipse dixit. A dogmatic and unproven statement. Rad. This lawyer has some sweet language. Don't Google it. Ipse dixit that consent to jurisdiction is equivalent to a permissive forum selection clause. Permissive clauses are not entitled to the Atlantic Marine presumption, Lavera, whatever, where a forum selection clause is instead permissive. The vast majority of courts have addressed the issue, have rejected Atlantic Marine application as applied, and applied the traditional forum nonconvenience test, adopting rule in the district. So Mitchell versus One Forge Government Solutions. Atlantic Marine applies only to mandatory forum selection clauses and not permissive selection clauses. Nexon's fictive forum selection clause is therefore of no legal moment. Okay, so what they're saying is that what Nexon argued in their opposal notification has no legal merit, essentially. And they're misconstruing clauses. Yeah, this lawyer is going ham on Nexon. or Nexon. It's like a whoopsie daisy. Yeah. There's just Iron Mason right now. It's just basically like Nexon is making up a bunch of shit. They're just making shit up. Essentially, in common speak, half of this argument has basically been Nexon's lawyers saying, or Iron Mason's lawyers saying Nexon's lawyers are a bunch of idiots and they're just making shit up to stall this case out, to drag this case out. Where 2T 25 right here. Nexon cites 2 out-of-circuit cases in its opposition and states courts have repeatedly held that where a plaintiff sues in a jurisdiction designated in a permissive forum selection clause, a defendant seeking to transfer a case outside of permitted forum must meet the heightened Atlantic Marine standard. This is not an accurate statement of the law in this circuit. Fucking own, dude. That's hilarious. I love Iron Mace's lawyer. Aaron J. Moss is a freaking baller. The Korean contractual forum selection clause governs so section B or paragraph B. Nexon cannot avoid application of the actual Korean forum selection clauses that govern this dispute. In an attempt to confuse the issue, Nexon loves scattershot arguments, none of which have any merit. Nexon first argues that the forum selection clauses in the parties' contracts are inapplicable because those agreements do not cover post-employment disputes. At whatever, this is false. The acknowledgement about company IP explicitly states that the prohibition on the use of Nexon's IP continues after this agreement is concluded, and that the former employee may not use or recreate outside of the company any covered IP. Similarly, the employment agreement states that confidentiality obligations apply not only during employment, but also after departure from the company. Nexon knows this. It alleged in its complaint that these contractual obligations meant that Nexon employees are prohibited from using or recreating work-related inventions made at Nexon, even after the employees leave at Nexon and join another employer. So that's what I was saying I think like not last stream, but the stream before that. Nexon is arguing 2 sides of the same contract. They're saying that the parts of the contract that they don't want to hold weight don't hold weight, but the parts that they want to be valid are valid. You can't do that. Once you start invalidating enough of a contract, the whole contract is invalid. So at this point, Nexon has to pick and choose, at least to the best of my knowledge, Nexon has to pick and choose whether or not they want the contract to remain valid or not. You know? So is the contract valid or is it not valid? Like, which one is it? Because if it is valid, you have agreed to this clause that states that you have to fight this case in Korea. So let's move it to Seoul. Sorry, I smacked the monitor. Or I smacked the mic. But if it isn't valid, then you cannot hold them to these IP clauses anymore. So which one is it? Do you want to fight the do you want to turn this into a contract case and use the contract and fight it or not? Because it seems like Iron Mace is willing to fight the contract, even though the contract, in my opinion, is way more damaging because of the IP selections that say that all the IP belongs to Nexon. But Iron Mace has to know something about the contract that I don't, because if I was Iron Mace, I wouldn't want this contract in play at all. I would say, fine, fight it in the US, but you can't use any part of the contract. This contract is now void. That's what my argument would be. But I'm not a lawyer, and I'm not nearly as smart as them. So they obviously know something I don't. But, yeah, but their lawyers are freaking they're a boss. Nexon knows this. It alleges in its complaint that these contractual yeah. Okay, I just went over that. The suit declaration is therefore directly contradicted by the plain terms and agreements of Nexon's own copyright. That is 100% fact. I mean, it's opinion, but as far as I'm concerned, that's fact. Because I've read the complaint, I've read the agreement, I've read the employment contracts. Like the contracts are pretty clear. What they what they consider IP and inventions and work related are all very vague. But how the mishandling of IP is very clearly defined, and it's anything that happens at Nexon belongs to Nexon. Otherwise, we're going to sue you. So they have to abide by these, and it says in plain English, well, translated English, that um, if there's any lawsuit even after the employee leaves, then it has to be fought in Korea. So, like, um, yeah. What's up, Pillow? You need like a TLDR? So basically, the TLDR of this is Iron Mace is accusing Nexon of lying on their last in their opposition to the dismissal. They're accusing Nexon of just blatantly lying, and they're accusing Nexon. They're not accusing them of perjury, but they're saying that they're lying, and that um, it's that basically all of the cases that they cited, Nexon cited it correctly, and I guarantee you they're going to get into a part where the fact that this is the most viewers I've ever had, by the way, 95. Holy shit! If I break 100 viewers, 100 concurrent, that will be a huge milestone. That'll be insane. That's like huge stream. That's like decent streamer numbers. And YouTube gets like usually terrible numbers. You guys are fucking awesome. I love you guys. You guys are amazing. That is incredible. That is insane. 100 concurrent? Holy shit. What the hell? What the hell? 100 concurrent. I love you guys. You guys are amazing. I don't even know what to say. Last night there was the war of the battle of the Andrews, and now I have 100 concurrent stream watchers viewers. That's huge. What the heck is going on? Oh my gosh. I have a new setup. You guys are changing my life, man. I know I've said this for like 3 streams in a row, but this is incredible. You guys are legitimately changing my life. Thank you. Thank you for the support. I can't even. Holy shit. I don't even know what to say. You guys are changing my life. This is an amazing. Andrew, thank you so much. I really appreciate you. You guys are crazy. This is why I call this kind of stuff is exactly why I'm calling court administrators. I'm doing it because for you guys, I want to know the information too. So I'd probably call them anyway, but like I'm coming on here and talking about it because I want you guys to know what I know, and there's a lot of misinformation. I'm not going to name names, but there's a lot of people who are genuinely curious and want to know what's going on. And I would rather just read the document and have you guys make up your own opinions, and I'll give my opinion on it too. And then I'm going to break all this stuff down with a lawyer friend and give a more concise, informed opinion later. But round 2, I love you guys, man. You guys are crazy. You guys are insane, and I love you. And this community is awesome. I can't believe I broke. Oh no. I love you guys. But yeah, this is why I do what I do, because of you guys, and I do this for you. I do this because it's fun. This is awesome. Hanging out with you guys tonight is like it makes me smile. I have a big ass smile on my face, and it's because of you guys. I have a light shining on my face, making the stream look good. I got a new microphone because of you guys. I bought the upgrade for that app, so now I have 4K video. Like, you guys are changing the stream. You guys are changing my life. You guys are amazing, and the Battle of the Andrews is amazing. And I don't know what else to say, but you guys are the best. This is the best community I've ever seen. Driving to the moon, hold the line. Dad will survive, and we're helping. We called. There was a few of us that called the freaking. I love you guys so much. Thank you guys so much. Hold the line. Driving to the moon. This is amazing. Um, you guys are crazy. I love you guys. Um, but yeah, you guys are why I do this. You guys are why I'm calling the District Court of Washington. If they allow in person, if they do any kind of in person trials, I want to go. Thank you, Cody, for the for joining. I appreciate you guys so much. If they do any in person stuff in Seattle, I want to go. I want to go, and if it's like multiple day thing, I'm gonna go like get a hotel and like stay up there, and or if I have to drive back and forth, I will. It's like 3 hours from where I live, so um, I want to go in person and like go take notes and see and like try to meet the guys from Iron Base and shit. I want to do this stuff, and I want to tell you guys about it. A third Andrew James. Which one is a King? King Andrew? I can't believe I have over 100 streamers. I can't believe you guys are giving me these supers. You guys are crazy. Thanks for joining the guild memberships. I love you guys. I showed you guys I showed you guys one foot in my leg tattoo. But yeah, we have me and Mrs. Dirt have some interesting stuff planned for you guys. But yeah, we want to make this stream and this channel awesome for you guys. We want it to be as entertaining as possible. The feet pick worked, right? It brought 100 people on. That's crazy. I can't believe I'm at 100 viewers right now. This is insane. It's all happening like crazy fast too. It's insane. I don't even know what to say. You guys are crazy, and I love you. She thinks that we're all nuts, but she loves it. She also plays games. She plays like Fallout and Borderlands, and she also played like Animal Crossing for a long time. Oh, you're playing the early access to Baldur's Gate? I played it really early on, and now I'm just kind of waiting for it to come out. We all are nuts. We are all nuts, but she loves it. She thinks it's hilarious. She makes fun of me all the time for like, she'll come in here and I'm translating Korean and stuff, and try to break into like Korean law documents, like trying to figure out a way to weasel my way into the Korean law circuit. But yeah, she loves it. She thinks it's hilarious, and she loves all of you guys. She's my moderator in here. She's the one who set all this stuff up, all the background and this like curtain, whatever, and these curtains. She set all this stuff up. She helped me get my TV off the wall and out of storage and put it up as my second monitor. She loves it. Yeah, I got that at PAX. It's pretty sweet. The Borderlands mask. There we go. I gotta see what it looks like on stream now. I did not go online. There we go. How's it? We need the hat. Let me. My hair's all messed up. There we go. Yeah, Lady Derp used to play. I sound like my old mic again. Lady Derp, Mrs. Derp used to play. It's so hot in this. It's so hot in this thing. Can't take it. My face got immediately sweaty. My face got immediately sweaty in that thing. Oh, I have no idea what rank I am in TFT. I play TFT. I play Aram a lot. I was like plat or diamond in ranked for a long time in for League. I've been playing since season 1, so it better be decent. That was actually a good example of the quality change that Mike did for the stream. And I'm like a good foot away from it too. It should be like, what's up, guys? It should be closer to this. So when I get my mic arm, it'll be a little bit, should be a little bit better. But yeah, right now it's like, ASMR. Yeah, when I get my mic arm, it'll be a little bit better. um, Getting bricked up for dad. I totally lost where I was on the document, by the way. No, it should be. So I should get my mic arm on Sunday, and then this is the Fifine AM80 or something. The AM8, Fifine AM8, whatever this is. But yeah, once I get my mic arm, it'll be somewhere around here, and then it's a low profile mic arm, so I won't have to like talk as Box or Link. I'm not sure what you mean. Line 18. Oh, yeah, I was right here. Defendant submitted certified translations for does this sound better, or can you guys hear that stupid whining in the background again? Yeah, it's a Fifine AM8. I have it plugged into USB-C right now. But the defendants submitted translations from a Korean court interpreter, arriving that the relevant forum selection provision states that all disputes relating to the contracts must be heard in Korea. And they state the actual part of the contract. Heck yeah, Andrew. Yeah, hit me up on Discord whenever. All of you guys, just like hit me up whenever. I'm down to hang out. Like I'm a part of the community because I like hanging out. I like talking to people. I work from home. I'm home all the time. So just hit me up, like whenever. Yeah, we'll play games and hang out. That'll be great. Next on offer is the tepid response that the Korean phrase "I cannot say that" could possibly mean other things, including arising out of, and submits a declaration from a translator who does not offer any certified translation. Oh, I never went over that document, the translator's document. So he doesn't ever offer that he's a certified translator? That's hilarious. Like a different Discord just for the channel itself. I might, because that the Shadows Below one is for my game. But yeah, there's a Discord for like all of my stuff. I think it's in the it's in the description. It might be. Let me see. If not, I'll add it. Yeah, join us on Discord. Yeah, there's a link in the description. So the translator wasn't certified. That's hilarious. So Nexon is offering arguments from uncertified translators. Great. So John, TLDR is basically Iron Mace is calling out Nexon for lying on a bunch of stuff. And we have found out. So I actually called the court administrator today, and the court administrator said that the 26th has been confirmed as like the honor before date for all of the like injunction and dismissal and all that stuff. Should be decided by then, the 26th. And then, yeah, I mean, that's about it. Iron Mace is basically just calling out Nexon as a bunch of liars and then saying all the stuff that they cited is like misconstrued information or bullshit. And then they went on to prove that the translator that they used in their last document, that Nexon provided, wasn't even certified. It wasn't a certified translation. In rebuttal to the J. Park declarations, defendants concurrently submit that the declaration of Professor John B. Duncan, PhD, in the Duncan Declaration, who taught Korean for more than 30 years and has extensive experience as a Korean translator and interpreter. Duncan Declaration. He explains that the word can't say that used in both contracts meaning relating to and could possibly or reasonably also be read as in connection with or regarding, but arising out of and based upon are unnatural translations inconsistent with the wording of the contract. So yeah, if it might be interpreted like that, you might be able to, but is that in line with the context of the contract is basically what they're saying, and they're saying it's not, right? Oh, just join the Discord? Oh, sweet. Heck yeah. Welcome to the Discord. So personal opinion on this so far, Nexon's getting their they're getting clowned on. If everything in this is true, which this is all statements under penalty of perjury, so this is true to the best of Iron Mace's lawyer's knowledge. So if all of this is true, Nexon's getting clowned on. Like they are just getting called out for lying on everything. It's hilarious. It's hilarious. It was geo-locked because it had. So what they didn't mention in their argument was that it was geo-locked because it was ordered to be geo-locked by the Korean courts. That's how they do their DMC, like their version of the DMCA. So they couldn't have released in Korea because there was a pending court case. So they had to geo-lock it. I highly doubt that them committing perjury would ever be proven in court. You'd have to. Perjury is a crime of intent. You have to prove intent with perjury. Cody, you have a wonderful night. Get some sleep. I don't want to keep you up too late. If I was Judge Lewin, I'd be pissed. I'd be pissed at Nexon already. But I'm kind of biased, so. But I'd be pissed at Nexon already. It depends on who's telling the truth, right? And if I looked into both of these statements, and if I had a better understanding of the law, and to me that it was clear that Nexon is bending the truth and omitting a lot of truth, and inserting a lot too much, way too much opinion, I'd be like, you guys need to cut the shit out. Like, what's your actual? Don't send me 20 or 35 pages of repetitive nonsense. That's nonsense. That's a lie. You're obviously just trying to waste my time and the court's time and Iron Mace's time. So she has to see through some of this stuff. So, however, Nexon misconstrues the forum selection provisions. They indisputably govern this dispute. Nexon's complaint explains in detail how the contracts containing these forum selection clauses operate to prevent Park and Choi from leaving Nexon to form a competing company like Iron Mace and using Nexon's trade secrets. And then they cite the contract. The scope and extent to which Nexon owns the intellectual property it claims has been infringed or misappropriated is directly determined by these contracts. While it is enough to show that this dispute has factual connection with the contracts, it is in fact it in fact hinges on their interpretation and inextricably intertwined with them. So yeah, like I said, the entire IP and trade secrets part of the contract or of the case relies entirely on the contract. So what they're saying here is that if Nexon wants to throw out the contract, they have to also throw out the intellectual property that it claims that Iron Mace is infringing on. So they're arguing exactly what I said I would be arguing. If Nexon wants to continue down the path of this contract isn't valid, they have to throw out all of this IP, right? I should have been a freaking lawyer, dude. Why didn't I become a lawyer? Yeah, right. No, way too. No, I would be so inappropriate. I would be too inappropriate to become a lawyer. So yeah, basically, if Nexon owns, like, if Nexon's entire case hinges on intellectual property that it claims has been infringed or misappropriated, is directly determined by these contracts. If they want to throw out the contracts, they have to throw out all that IP too. But the case, in fact, hinges on their interpretation and inextricably intertwined with them based on this contract. It's written right here in these two statements. And that's what I've been saying for like the past 3 weeks. Like, Nexon is fucking themselves over, like, hard. And Iron Mace is calling them out on this. I mean, when I say it, it doesn't sound as fancy as the way they say it, but yeah, you can only have it one of two ways, Nexon. You can't have your cake and eat it too. You can't throw out half the contract and keep the other half. Like, that's just not how contract law works in any country, as far as I know. Any country that has any kind of reasonable expectation of law. Like, that's not how that works, at least to the best of my knowledge. And my buddies who are literally corporate lawyers and IP attorneys. Like they're like, I don't know why they would, if everything is reliant on this contract, Iron Mace is just going to say, you can't have it both ways. And this is basically exactly what is happening. But yeah, that wasn't me who came up with that. That was actual lawyers, not me. I'm just taking credit for what my friends said. Because I just take what they say, put it into my own words, and then repeat it back to you guys. Because they ain't got time for this because they're busy suing people. So Nexon's next asserts that under Korean law, a mandatory forum selection clause reflects only an agreement as to which court within Korea will hear a dispute. Even if this were true, it is immaterial. Federal courts apply federal law, not a foreign court's law. This happened in Korea. In interpreting a forum selection clause, the court follows the weight of precedent within the circuit court to apply federal law, irrespective of the agreements of choice law provision selecting German law. Manetti, Faro, Inc. versus Gucci, AM. Federal law governs analysis of the effect and scope of the forum selection clause. In Ninth Circuit Court, forum selection clause governs disputes relating to the contract, encompasses all disputes with logical or causal connection to the agreement, which this dispute clearly has, because they were former employees of Nexon, and they were under the contract that Nexon signed, that they signed. Like, everything's so. To kind of sum this up, in as simple of a way as possible, Nexon is trying to simultaneously argue 4 different things. They're trying to simultaneously argue that Mr. Choi, Mr. Park, and Iron Mace are all 3 separate entities. So Iron Mace is not held to this contract. Therefore, Iron Mace cannot have this case dismissed. Then at the same exact time, they also made the same argument that Iron Mace Iron Mace, Mr. Choi, and Mr. Park are all so closely linked together that they're all liable for parts of the parts of the contract that they want to hold truth, including the IP law is what they're trying to get Iron Mace out on. But if they're all separate entities and Iron Mace didn't sign this contract, then the entity of Iron Mace is not responsible for the trade secrets theft, because the company wasn't even founded when the company as an entity wasn't founded when Mr. Park was fired or Mr. Park quit and Mr. Choi left. And Iron Mace also never signed the contract with Nexon. It was never mentioned in the contract, so Iron Mace has nothing to do with it. So Nexon is also arguing that parts of the contract are valid, but other parts aren't. So what they're essentially arguing is that parts of the contract, or that the contract is both valid and invalid at the same time, and Iron Mace is its own entity, and Iron Mace is part of Mr. Choi and Terrence inextricably. Like they're both invariably linked, or like they can't be separated. And so you can't have all four of those things simultaneously, and that's exactly what Iron Mace is saying. Is like you're arguing out of both sides of your mouth, and that just doesn't work, right? You just can't do that, especially in court. Like that's bullshit. So federal law governs the analysis of the effect and scope of the forum selection clause, and the Ninth Circuit Court forum selection clause governing disputes relating to the contract encompasses all disputes with a logical or causal connection to the agreements which dispute clearly has. I just said that. Nexon also suggests that because there is pending litigation between the parties in the Suwon District Court, defendants may not invoke a forum selection clause in favor of the Seoul District Court. Nexon offers no authority that the parties' decision to litigate a dispute in a different Korean venue invalidates their plain terms of the forum selection clause, nor are defendants asking for the court to transfer this action to Suwon. The proper remedy is dismissal, and whether the parties continue to litigate these issues in Suwon or Nexon chooses to initiate a new action in Seoul is irrelevant. That's kind of what I said. That's almost exactly what I mean. In different words, that's exactly what I said last night. It doesn't really matter what's happening in Suwon because that's Iron Mace suing Nexon. That case is completely different than this case. It covers the exact same stuff, but if the case in the United States is dismissed, especially if it's dismissed with prejudice, then the only recourse that Nexon has is then to start a new lawsuit in Seoul covering the same thing, in which case both of those cases will most likely be combined anyway, and the court will decide which one is the proper venue, Seoul or Suwon. That's the course of action that would most likely happen. If Korea's law follows the same structure as the United States, they won't have two simultaneous cases that are exactly the same going on, except versus each other. What they'll do is they'll combine suits, and then the court will say which one has precedent, right? Which jurisdiction is the proper jurisdiction. So, Rockstarification, possibly, but if that's their strategy, it's biting them in the ass very heavily right now, because Iron Mace is calling them out on it very hard, and a lot of what they're saying in this document is opinion, but it's also backed up by fact, and they're actually directly quoting lawsuits, whereas almost half of the citations that Nexon did in their opposition was internal citation needed. They didn't even cite the cases. It just said a case number with no quotation. So if the case by chance does get dismissed in the U.S., WECO, I think that they will probably release EA, because there's going to be a small window of opportunity where releasing EA or early access is completely legal. It might piss off the Korean judges, but in the United States, as far as Iron Mace is concerned, they can release in the United States completely legally. they wouldn't be able to release in Korea, or I don't know if they could release anywhere else, but they would have direct permission in the United States to release. Because yeah, so there'd be a window of opportunity where Iron Mace could release the early access, and Nexon couldn't send out DMCA's in the United States because the DMCA has nothing to do with Korea, unless it goes through the Hague or World Trade Organization or WIPO. But that can take months to put stuff through there. So they could release early access, and then there's a window of opportunity where our Nexon would not be able to send out DMCA's until they put forth an appeal, and that appeal was accepted, and then they could do a DMCA again in the United States. But by that time, the game will have already sold like hundreds of thousands of copies. Yeah, that would suck. But I mean, the Americans would. I mean, that would suck for literally everybody else in the world. It would be really good for Iron Mace because it'd make tens of millions of dollars. It would put the Korean judge in a tricky situation. I think it really depends on the timeline of it. So if the case gets dismissed on July 26th, and say the case gets dismissed on July 26th, and the injunction gets scheduled to happen on like, August 3rd in Korea, because you got to remember that they have on or before 30 days to schedule the injunction after the 19th in Korea. So that's August 19th at the latest for the injunction hearing in Korea. So if that comes around, if they get word, so Iron Mace is going to try to get that scheduled as quickly as possible, right? The 19th is going to happen, and Iron Mace is going to try to get that injunction hearing scheduled as fast as humanly possible. Because if they could get that injunction hearing like on the 25th, like 6 days later, then they can have all this wrapped up by the 26th, right? So right now they're trying to get the game back on Steam is essentially what they're doing. But yeah, so there's a window of opportunity, and it really depends on what happens in Korea, because that decision is going to be a global decision. But so if the DMCA doesn't happen, the Korean courts can only force Iron Mace to geo-block Korea for now, unless it gets a full injunction. So if Nexon gets a full, like if Nexon outright wins the injunction process in Korea, Iron Mace has to stop developing and everything until the case is over. They can't sell, they can't develop, they can't do anything until the case is over. But until that happens, they could basically do whatever they want except for sell in Korea. Nothing, technically, Phantom. But the thing is, if you start putting out frivolous lawsuits, you'll actually get fined in a lot of countries, especially in Europe. Like, European courts do not fuck around with this kind of stuff. Like, at all. Frivolous lawsuits are not a thing in Europe. Not like they are in the United States. Like, it just doesn't happen, because they'll fine your ass. If they're like, you already have 20 of these cases going on in the rest of the world, like, sorry. Wait till one wins, and then we'll institute that action over here because we're part of WIPO. And the standard procedure is if you win in a country that is part of WIPO or the World Trade Organization, the rest of those countries will uphold that rule because they all service each other. They all uphold each other's rulings, right? So whatever happens in Korea will effectively go to the rest of the world. Whatever happens in the U.S. just affects the U.S. for right now. Because they're based in Korea. But since they're based in Korea, if say Nexon wins in Korea, that ruling is like global basically. And then every other country will just uphold that ruling. And that so Nexon, if Nexon then tried to sue in every other country that Iron Mace released in previously, they would just get fined. They would get fined into the ground. But if they win, also if Iron Mace wins in Korea, that's a global decision as well, right? Because the United States, if they try to sue, so say Iron Mace wins in Korea, and then Nexon tries to sue them in the United States again, or tries to sue them in Europe, like the European country they tried to sue them in will just be like, hey, we know that you guys already got your ass kicked in Korea. Here's a fine for here's a fine for wasting our time. See you later. You know. Um, yeah. So I think honestly, that's what I think is going to happen. The worst that happens is EA happens, and then IM gets a bunch has to. My theory this whole time is basically that early access is going to happen. Nexon's or Iron Mace is going to release, and then the case will settle before November, like November 21st. Because at some point in time, this case is going to end up costing more money than a settlement. So, whenever that time comes, Iron Mace will probably settle. Um, so this proper remedy is dismissal, and whether the parties continue to litigate these issues in Suwon or Nexon chooses to initiate new actions in Seoul is irrelevant. Nexon's argument also misrepresents the facts. Iron Mace sued Nexon in Suwon on exactly. An Iron Mace sued Nexon in Suwon on claims of business. It's not Nexon versus Iron Mace. It's Iron Mace versus Nexon in Suwon on claims of business interference because that is where Nexon is located. Supplemental declaration. That's exactly what I said in the last stream. Supplemental declaration of Jung Junjian. While it is doubtful that Iron Mace's Korean claims implicate the forum selection clause in Park and Choi's employment agreements or acknowledgments about IP, defendants have never taken the position that these clauses are invalid, unenforceable, or inapplicable to the dispute. Finally, Nexon asserts that Iron Mace is unable. So yeah, Iron Mace has never said that the contract is invalid. They just said that or unenforceable. What Iron Mace has said is that they didn't break it. Iron Mace themselves didn't break any laws. Finally, Nexon asserts that Iron Mace is unable to invoke the forum selection clauses because Iron Mace was not a party to the agreements. Defendants already cited directly on point authority addressing the issue, citing W Boxed Meats distributors. Nexon has not even attempted to refute that authority. Korea is an available, adequate alternative forum. Nexon demonstrates the adequacy of Korea as an alternate forum by suing defendants there on the same claims. So when they countersued, when Nexon countersued Iron Mace in Korea, they in turn basically proved that Korea is the place where this should be taking place. So Nexon demonstrated the adequacy of Korea as an alternative forum by suing defendants there on the same claims and seeking the same relief as it does from this court. Nexon nevertheless asserts that the adequacy of Korea as an alternate forum is a mirage because a Korean court cannot compel Iron Mace to produce its dark and darker source code. The only mirage is Nexon's argument, which is both false and legally irrelevant. As threshold matters, courts routinely hold that a foreign forum is not adequate because depositions are not available or because it provides more limited discovery tools than the home forum. Limitations on document discovery cannot render a forum inadequate, and Nexon cited no authority holding otherwise. So they're basically just talking out of their ass, making stuff up and stating opinions. Even if this were true, Nexon could not obtain Iron Mace's source code in Korea. That is merely a discovery impediment. It does not preclude any relief whatsoever. Nexon's core allegation is that Dark and Darker the game infringes on Nexon's P3 game, While comparing source code might aid in that analysis, it is the games that must be compared. Defendants use those materials to develop substantially similar video games. Nexon brings this action to stop defendants from continuing to profit from the distribution of Dark and Darker in the United States and elsewhere. So what they're arguing is that Nexon's own claim has nothing to do with the source code at all. It's actually that the games themselves as a whole are similar. If you remember Nexon's original complaint, their whole argument is that they don't want to look at the source code because they know that's different at this point. They don't want to look at the source code individually. They want to look at the games as a whole and how similar they are. They don't want to look at the cake's ingredients. They want to look at the whole cake, right? And you can't really. That's difficult to do in IP cases like this, especially with web development or with any kind of digital product. Because there's going to be a lot of similarities in almost every game that's in the same genre, right? Any fantasy extraction game is going to have similar game elements. Any extraction game, even whether it's sci-fi or fantasy, is going to have some similar elements and overlap. A lot of MMOs have the same exact material. So they can't argue that they both need access to the source code and that the source code is irrelevant. They're making two simultaneous conflicting arguments again. So this is like the fifth one that we've seen. They're making like 5 conflicting arguments and fighting both sides. So do you need the source code or do you not want the source code to be looked at? Which one is it? Right? Because if you don't want the courts to just look at the source code and instead look at the game as a whole, then why do you need the source code to be brought up in discovery? And the courts can ask for the source code in discovery in Korea. It hasn't, because again, a third party, as to the best of my knowledge, a third party investigator has that. Why would a judge who knows nothing about coding give a shit about the source code? They're going to give it to a third party. They're not going to give it to a court clerk. They're not going to give it to a judge. Like, it just doesn't make sense. Nexon's arguments legitimately don't make sense. At least in my opinion. Nexon brings this action to stop defendants from continuing to profit from the distribution of Dark and Darker in the United States and elsewhere. But even if the unavailability of Iron Mesa's source code were an impediment to relief and could render Korea an inadequate forum, Nexon misrepresents the law and facts. Under Korean law, parties can ask the Korean court to issue a document submission order, Jean Sup Declaration, whatever, paragraphs 7 through 21. If a party refuses to produce documents subject to that order, the court can draw evidentiary interferences against that party. So the courts will put up a fine or charge them, just like in the U.S. Nexon's argument is the highest of bad faith because Nexon has not even made a request for document submission order in Korean litigation as to Iron Mesa's source code. That's huge. That's fucking insanity. Nexon has not even made a request for a document submission order in the Korean litigation as to Iron Mesa's source code. Nexon hasn't even asked the courts for it. They haven't even asked the courts. That's insane. That's insanity. What the hell is Nexon doing? How are they going to argue that Korea is an inadequate forum because the courts haven't given them any documents when Nexon has? They forgot to mention that they haven't even asked for any fucking documents. Like, what the fuck, dude? Their entire argument was that they can't get the documents. They haven't even asked for them yet. Yet Iron Mesa is willing to provide them to a third-party investigator when Nexon hasn't even asked for them? That's insanity. That's crazy. So Nexon has invented a discovery impediment. Yeah, it's just making shit up. Nexon has invented a discovery impediment that does not exist to justify a legal theory that is foreclosed by controlling precedent. So basically what they're saying is that they've invented something that doesn't exist because there's already laws in place that contradict exactly what they're saying. That's insane. The private and public interest factors favor dismissal. The private interest factors for, and this is they're saying this again under threat of perjury. So like if this is false and they're proven to have lied on purpose to intentionally mislead the court, they could go to jail and the lawyers would be disbarred. More likely or not, they'd be fined a shit ton of money and not go to jail because it's a corporation. But still, that's crazy. The private and public interest factors favor dismissal. The private interest factors favor dismissal, while controlling mandatory Korean form selection clauses obviate any need to consider the private interest forum non-convenience factors to support dismissal. Nexon has no persuasive arguments to the contrary. First, Nexon relies on the same supposed unavailability of source of proof, including Iron Mesa's source code, but Korea has adequate discovery procedures allowing Nexon to obtain the evidence it seeks. Nexon cites no authority that discovery procedures of alternative forum bear on the private interest factor. Second, Nexon dismisses the convenience of the parties that the location of witnesses arguing that they can be compelled to travel to the U.S. or otherwise testify remotely. But given the reduced differences due to non-resident plaintiffs' forum choice, the inconvenience to defendants and witnesses is particularly salient. So that means what Nexon claimed is wait, hold on, devil's advocate here. Devil's advocate here, if it's crystal clear that asking will do nothing because in Korea IM doesn't need to, you can't blame them for not asking. That is also true. But however, they stated under penalty of perjury that there's a law in place in Korea that demands that the Korean courts will submit a document. If the Korean courts think that it's valid for them to ask for this, for Nexon to ask for this, the Korean courts can submit a document submission order right here. It says that right here. Under Korean law, parties can ask the Korean courts to issue document submission order. Whether or not that Korean court is going to comply or not is a completely different story. So if you're a lawyer and you think that there's a 90% chance of, so like this is a perfect example. Even if like realistically there's like a 10% chance of this case getting dismissed, right? So there's like a 10% chance of this case getting dismissed. But they're still asking for the dismissal, right? And they're still arguing for it. So if there was even a 1% chance that they could get a hold of the source code by asking a judge in Korea, they would ask. It's just illogical for them not to ask. Because if there's a chance, there's a chance. At all. No matter what the percentage is. And it also makes it a good faith argument. It turns their bad faith argument it would help their case in the United States, right? Knowing that they're going to get denied and asking for it anyway, and then getting a denial by a judge would give them a factual statement that they could then submit as evidence. Like, hey, we asked for the source code and got denied in Korea. Look how terrible the Korean courts are. That would be way bigger proof than just stating that they can't get it without any proof that they can't, right? It would be a proof of burden. They would have factual evidence that the Korean courts are acting in a preventative manner towards Nexon. But they didn't even ask. So that's why that statement is so huge. And that's why if you're in court, if you're ever in court and your attorney or lawyer ever says, nah, the chances of that are very low, but it might help your case significantly, you always make them file for it. Even if it's going to cost you more money, even if it's going to upset somebody, like you have to usually ask for that kind of stuff. Line 26. Yeah, but thank you for asking. But that's huge. yeah, it's. I mean, devil's advocate. I'm all for devil's advocate, and thank you for asking that question because it does shine a lot of light onto why didn't Nexon even ask? Well, if they knew they were going to get denied outright, they should have asked because getting denied would have actually helped their case, right? It would have helped because then they could have went to the judge and been like, "Here's my doctor's note, right? I have a case of inability to get information, right? So I have to fight this here because this is the only jurisdiction I can get that information." However, if they asked for it and received it, then they wouldn't have been able to make that argument at all. Yeah, asking and being told no is way different. And then what if they asked and got approved? Then their entire argument that they can't get the source code is debunked, right? Because then Iron Mace would be like, no, we gave them our source code and they're committing perjury. They can't then come to the U.S. and be like, we couldn't get it, even though they're sitting on a stack of source code documents. Like, come on, man. Not you, but like, come on, Nexon. They're just a bunch of, they're crazy. So where was I? While controlling mandatory Korean form selection clause obviate need to consider private interest form non-convenience, those Nexon has no persuasive arguments to the contrary. First, Nexon relies on the same supposed unavailability of source of proof, including Iron Mace's source code, but Korea has adequate discovery procedures allowing Nexon to obtain the evidence it seeks. Nexon cites no authority that the discovery procedures of the alternative form bear to the private interest factors. The argument does not pass superficial scrutiny. If Nexon believed that Korea cannot provide any remedy for a claim of copyright infringement, why did it sue Iron Mace there? That's hilarious. That's fucking hilarious. Defendants are unaware of any decision ever finding Korea an inadequate forum by virtue of its any decision. Defendants are unaware of any decision ever finding Korea an inadequate forum by virtue of its discovery procedures. Fucking mic drop, dude. That is Aaron J. Moss is my hero. I fucking love this guy. This is hilarious. This is hilarious. Nexon is a bunch of turds, and their lawyers are a bunch of idiots. God, this is why. So this is exactly why Nexon's lawyers are known for finding settlements and not winning. Nexon's lawyers are not a winning law firm. They are a settlement law firm. They don't have a very strong reputation of actually winning anything. In fact, I think it's like 90% of their cases go to settlement or more. It's like above the national average. So like all of their cases go to settlement. They're not like, oh, we win 40% of our cases, which is like huge, right? And like 40%, we win 40% of them. I haven't really looked, honestly, I've looked more into Nexon's lawyers. I haven't really looked into Aaron Moss. I do know that Aaron Moss has won cases in the Supreme Court. Aaron J. Moss has won cases in the Supreme Court. I believe he's also helped shape like national law through the Supreme Court cases. So like he's a baller. I know that he's a baller lawyer. And that the law firm he works for is like huge. So they like are super good, but like this is hilarious. This is insane, and I love this guy. I freaking love this guy. So second, Nexon dismisses the convenience of the parties and the location of witnesses, arguing that they can be compelled to travel to the United States or otherwise testify remotely. But given the reduced difference due to non-residential plaintiffs' forum choice, the inconvenience to defendants and witnesses is particularly salient. See Knox, whatever. Indeed, because the defendants seek to dismiss this action in favor of the forum, where all parties are headquartered, that alternate forum would increase the convenience for both parties. Yeah, so remember that Nexon's argument was that Valve and AWS are both headquartered in Seattle, and that's where the DMCAs are taking place. And having them go to Korea would constitute an unfair burden on them because they're like third parties, and they're based in the United States. But at the same time, if AWS and Valve agreed to assist Iron Mace in this case and act as witnesses for them, or they were subpoenaed in Korea. Korea can't force them to go, so they would have to agree to it. AWS and Valve are like some of the richest companies in the world. Like literally some of the richest companies in the world. Nexon is it's like the top 5 richest companies in Korea. Outside of and its competition is literally Samsung. So the fact that Nexon is making an argument that it would place an unfair burden on Nexon, AWS, and so Nexon, Amazon, and Valve is hilarious. They have a combined like trillions of dollars of some crazy shit versus some coders and devs and like some people who worked for Nexon, like going all the way to the United States, paying for hotels, and like it's insane. So yeah, that argument's just literal insanity. This is not a case in which witnesses are scattered around the globe, and where defendants would need to identify specific witnesses who cannot otherwise be brought to the U.S. So courts could weigh their relative distribution and importance. See Boston Telecommunications Group versus Wood. Rather, every witness is in Korea. Well, that's not really true. Valve and AWS can be subpoenaed as witnesses. Nexon briefly suggests that. Oh, right, never mind. They're going to refute that right here. Nexon briefly suggests that Valve and Amazon might have information concerning the defendants' infringement and misappropriation, but does not explain what that evidence is. Yeah, like I said, they don't provide any evidence for it. Information concerning defendants' infringement and misappropriation, but does not explain what that evidence could be or why it would be relevant, much less why it would be unobtainable through third-party discovery or through party discovery. Nexon also downplays the immense burden on the parties and courts to conduct this litigation in the United States, when relevant evidence will be in Korean. While it is true that common coding languages use some English words, the code itself is all but indecipherable to the lay person, which is going to be true because it's going to be some kind of hodgepodge of like English coding with Korean notations, right? The actual notes contained in Iron Mesa source code describing its functionality are almost exclusively in Korean. Exactly. Supplemental declarations of Terrence Park declaration. So 2 is essentially all of the preparatory and planning documentation that went into making Dark and Darker. So all of the planning stuff is in Korean as well. Yeah, this is huge. This is huge. And it's like mostly factual too, which is cool. There's a lot of opinion threaded in here, but like it's like here's an opinion followed up by a fact, right? It's not like here's an opinion followed up by a vague reference to a court case with no citation. It's here's an opinion followed up by immediate citation and references and direct quotation in line with the opinion, right? Or it'll just be like, here is a fact. Here is the actual law here's the quotation from the law, the legal statute, the code, everything. So yeah, this is rad. My mustache is making my nose itchy. Indeed, Iron Mace has an internal wiki that detailed its game design written in Korean. It's disingenuous for Nexon to suggest that conducting all discovery, let alone trial, in English when nearly every witness speaks and corresponds in Korean would be a minimal inconvenience to the court and parties. Courts routinely find that such translation barriers are grounds for granting a forum non-convenience motion. See Nai Cho versus Boeing. Affidavit submission Chang versus Boeing Co. Granting forum non-convenience motion where virtually all of the evidence relating to the proof of damages is in Taiwan, where overwhelming majority of claimants reside, and the difficulties of adjudication these foreign damages claims would be compounded by the president's language and barriers and the necessity for translation. Granting forum nonconvenience motion in part because the necessity of having testimony and documents translated by qualifying translators would add significantly to the cost, likely duration, and complexity of litigating the case here. So then it goes into public interest. Whoa! I didn't know that, Brain. Aaron Moss represented the estate of J.R.R. Tolkien. Yeah, this is Nexon versus Iron Mace. And so this is Iron Mace's rebuttal. What just happened? Okay, there we go. So public interest. So section B or paragraph B, in asserting that the public interest or section B, sorry, public interest factors supporting retention of this jurisdiction, Nexon relies exclusively on Lang Van Incorporated for the proposition that copyright infringement cases involving infringement directed towards the United States are more amenable to suit in the United States, but Lang Van is a case about personal jurisdiction and is entirely, and its entire discussion about conduct. Wait, hold on, I got to start that over. But Lang Van is a case about personal jurisdiction. Okay, so it's not about venue, and its entire discussion about conduct purposely directed towards the United States was in the context of the Calder effects test for establishing personal jurisdiction over non-resident defendant. The Ninth Circuit only briefly addressed the defendant's argument about forum nonconvenience and simply noted that A, the plaintiff was a forum resident, and so that the alternative forum would have been inconvenient, and B, Vietnam was not an adequate alternative because Vietnamese courts had no experience litigating intellectual property disputes. Vietnamese civil and criminal courts are not a realistic avenue for copyright owners. To date, there have been relatively few civil court actions involving copyright infringement in Vietnam. You know why? Because Vietnam is communist. Their copyright laws don't really they're very, very, very different. Like, nothing against them being communist, like they could choose their own form of government, but having being a communist country has implicit copyright issues. So that case is there's a very, very, very real reason why you wouldn't want to fight a copyright case in Vietnam or like China specifically, because a lot of the copyright and intellectual property is de facto owned by the government, right? Because it's communist, unless you get explicit approval to own that copyright. There's special processes you have to go through to like invent and own proper copyright, similar to the U.S., but usually it's like defaulted to the government. As far as what I know, they're like the ultimate copyright owner, and that's to like protect medical devices, scientific stuff, and like scholastic information and all that. They have reasoning behind it, but it's completely different than the United States or Korea or like most other countries. So you'd want to fight a Korean copyright case in you want to fight a Vietnamese copyright case in Vietnam, and a United States copyright case in the United States, wherever it was actually infringed, because they're so different, right? Lang Van did not even discuss the public interest factors. Yeah, because they didn't have to, because Vietnamese copyright law is so different than the United States that it doesn't really matter. public interest doesn't even come into play because you can't. It would be literally impossible to argue a Vietnamese copyright claim in the United States. It's Aaron J. Moss, Funny Valentine. By contrast, Creative Tech cited that in defendant's motion is directly on point. Nexon has no response other than to claim in a footnote that the case found no similar targeting of the United States, but that is not true. The court did find that the defendant distributed allegedly infringing products in the United States, including through the defendant's U.S.-based subsidiary, Creative Tech. Describing how the defendant marketed its product in the United States, the court then squarely addressed the argument that the U.S. has a strong public interest factor in resolving this copyright claim. It held that federal copyright laws do not serve this purpose of protecting consumers. They are designed to protect the property rights of copyright owners. As such, the key interests in the dispute lie with the foreign corporations, not the American public. So to here, the people of Washington have no interest in protecting a foreign conglomerate's intellectual property in a foreign dispute. That's freaking hilarious, dude. Also true. I mean, that's opinion, but in my opinion, it happened in Korea, dude. You can't argue. If you stole a TV in Korea, the theft has to be argued in Korea. You don't then go to just because it was sold in America doesn't mean you argue the theft in America as well. You argue the sale of it in America and the theft of it in Korea. But if you can't even prove that it was stolen to begin with, your case of selling stolen goods holds no water. That's like the best simple example I could give. The people of Washington have no interest in protecting a foreign conglomerate's intellectual property in a foreign dispute. Even if the directing conduct at the United States could give Washington an interest in an intellectual property dispute between non-residents, Nexon grossly overstates that purposeful direction. Iron Mace developed Dark and Darker for a global audience, as nearly all video games are released worldwide, and the U.S. is the third most populous country in the world. That is not the same as targeting Washington. Iron Mace publicly playtests involved game servers located in Korea, Brazil, Germany, Australia, Singapore, Japan, and the U.S., all major gaming markets. The argument that Korea was geo-locked from playtests is also inaccurate. 6 of the 7 playtests were available in Korea in the Korean language. Only the last place in April 2023 were inaccessible there. Defendants have not directed their conduct at Washington, and even if they had, purposeful direction was not the standard for determining whether Washington has an interest in this dispute. Nexon's argument that though it is a Korean company, it has employees in the U.S. and thus has a material stake in the United States intellectual property system, is similarly foreclosed by Creative Tech. There, the court expressly considered it a foreign company that transacted business in the United States and had a wholly owned U.S. subsidiary, and concluded that those facts did not impact the forum nonconvenience analysis. Yeah, it's two different. Even though U.S. or Nexon or U.S. is a subsidiary of Nexon Korea, it's its own independent U.S. company. Just because it's a subsidiary doesn't mean that it's both part of and not part of. Nexon U.S. has to abide by U.S. laws. Nexon as a whole has to abide by Korean laws. But if Nexon U.S. violates a Korean law in the United States, it doesn't matter, right? Because they're based in Korea. Like, if there's some weird Korean law that says you can't spit on the ground on a Tuesday, and some dude in Nexon US does that, he's not going to go to jail because he's in the United States. Yeah, it's just profit sharing. Yeah, basically. It's just, yeah. Korea requires that the game must be rated like movies before distribution. When a game is available on Steam, the distributor can rely on Steam's rating. Once removed from Steam, Iron Mace could no longer satisfy Korea's requirements. Ironically, then the only time Dark and Darker's connection to Korea was even slightly diminished was when the game's sole connection to Washington was eliminated altogether by virtue of Nexon's takedown notice. That's hilarious. So the reason why they had to geo-lock Korea was because of their... oh, was that for me? Thank you. How you doing? I got brought of water. My lady doesn't want me to die of thirst. Thank you. So that's pretty funny. Due to Korea's consumer protection laws, there was no rating on the game because it was rated through Steam, and apparently Korea finds Steam's rating system valid enough for for sales in Korea. And because it was no longer on Steam, they couldn't sell it in Korea, and that was the only reason why it wasn't sold in Korea. So I was wrong about why they couldn't sell it, but yeah. Thank you, Craig Hampton. Thanks for joining the stream. So yeah, they're two completely separate entities. But what? Yeah, Nexon US is owned by Nexon Korea. But Nexon US isn't really subject to Nexon Korea's law unless they're specifically doing business in Korea. But they would be doing that business through Nexon Korea, so it doesn't really matter. Nexon US can't sue, since Nexon Korea is the copyright owner of P3. Nexon US cannot sue Iron Mace for copyright infringement of P3. Say I actually went and stole all of P3's data and just remade P3 and released it publicly. Nexon US wouldn't be able to do shit about it. It would have to be Nexon Korea, because they're two separate entities. Legally speaking, one is just owned by the other. It's like, I think like whoever owns that food group for that's KFC and A&W and all them, they own the rights to like Dr. Pepper or whatever, So like Dr. Pepper is its own company, but they're owned by whatever food group. Washington simply does not have any interest in an IP dispute between non-residents. Our non-resident parties, the court, need only to look at the complexities of this motion to recognize that it will be an unjust burden on Washington, its citizens, and the court to adjudicate this entirely foreign case. The parties have already submitted competing evidence regarding the proper Korean translation of just a few words in the relevant forum selection clause. See Nibiru Tech Ltd. Limited, justifying dismissal, where the court does not even the court notes that even during the earliest stages of this litigation, the parties have several times raised concerns with regard to whether the translation of particular documents is inaccurate or is accurate. That will be only the tip of the iceberg if this litigation continues in this inconvenient form. Okay. Oh, and then that's the end of it. Certification of service signed. Oh, sweet. So that's it. Okay, cool. Oh, Stosh, you joined right at the end. So for anybody who just joined right at the end, this whole thing was a rebuttal to Nexon's argument against the case getting dismissed. And this argument came out today because today is the first day that they could have ruled on the dismissal. It wasn't guaranteed to be ruled on today. There was no verbal arguments. I literally called the court administrator to confirm this. There was no verbal arguments held today, or no oral arguments held today. And the rebuttal used a lot of factual information, opinion verified by fact. Like the way that this worked. Well, I'll continue with what my call to. So before I get into the document, I called the court administrator today. They confirmed the 26th as the date for the injunction hearing, and it's the final date that the dismissal, they should know about the dismissal, or like everything should be wrapped up by the 26th in the United States for the injunction, the dismissal, and other pretrial hearings. That is confirmed by the court administrator. There was no verdict on the dismissal yet. There's no verdict on the injunction. All that stuff will happen most likely on the 26th or before the 26th. And that's as confirmed by the court administrator. And then this was Iron Mace's response to Nexon's previous document that I read yesterday. And as I was saying yesterday, in yesterday's live stream, where I read that 37-page whatever, and the day before, a lot of Nexon's argument was based on opinion and not full statements, like not fully factual statements. They would speak in like partial truths, but then leave a lot of stuff out. And they weren't actually quoting a lot of the suits that the precedent that they were citing. They would just cite a lawsuit and then not give an excerpt or quotation. They would insert like quotation not here, right? So it was yeah, I don't want to say intentionally misleading, but it was somewhat misleading context. It was like out of context information. A lot of it was opinion, not based on fact. And they made a lot of very bold claims and just kind of made some shit up, but claimed it was opinion, and then tried to throw some court cases in there. And yeah, they left out a bunch. If this wasn't a legal case, Andrew, I would completely be agreeing with you. I hope you understand that. I'm not like trying to be argumentative or anything, but because this is a legal document, and like I am who I am, I want to try to stay as on the level. But like if this was me, I would say that these guys are a bunch of fucking liars. That's my personal opinion. But as like a person trying to come off as somebody, as somebody who wants to like be representative of this, not like an expert, but like trying to help the community in an somewhat unbiased and like factual way. I don't want to say that they're intentionally doing anything, but yeah, they were speaking in like kind of a half truths and repeating a lot of the same information over and over in different ways, but never really getting to the point. And then this is just like a complete rebuttal using nothing but opinions based up directly after, based up by fact or precedent, citing legal statutes, citing and quoting. Like everything is quoted. They didn't leave out a citation from, like, as far as I know, they didn't leave out a citation from more than like 2 or 3 cases that they cited. And they cited legal precedent. They cited actual law, not just lawsuits. They tried, they did a really good job of in this rebuttal of just being factual. And then they also dropped like subtle, not even subtle, but blatant just bombs. Where was it? My favorite one was, where's the bold? Like, this is my favorite one. The argument does not pass superficial scrutiny. If Nexon believed that Korea cannot provide any remedy for a claim of copyright infringement, why did it sue Iron Mace there? Defendants are unaware of any decision ever finding Korea an inadequate forum by virtue of its discovery procedures. That is a very clear summary of how this document went. Nexon is completely misinterpreting laws. They are bending the truth of what happened in those cases, and they are making a bunch of false statements. So that right there is huge. And then there was another one. Where was it? So that one's pretty good too. There was another one though that was like a banger. Is that it? Yeah, that was it. It's a footnote somewhere. I think it was that one. Yeah, there was like 2 banger footnotes. Nexon cites 2 out-of-circuit cases in its opposition and states that courts have repeatedly held that where the plaintiff sues in a jurisdiction designated in a permissive forum selection clause, the defendant seeking to transfer a case outside the permitted forum must meet the highlighted Atlantic Marine Standard. That is not an accurate statement of this. That is not an accurate statement of the law in this circuit. Declaration 47 is a banger. Footnote 5. So oh yeah, the one that the reason why it wasn't put on sale in Korea was because it wasn't able to meet the reason why they had to geo-block Playtest 5 in Korea was because of the DMCA. That one was hilarious. So Mr. Decimate, we just finished reading it, and I'm going over a TLDR. But yeah, this statement here kind of clearly sums up how this entire document went. This argument does not pass superficial scrutiny. If Nexon believed that Korea cannot provide any remedy for a claim of copyright infringement, why did it sue Iron Mace there? Defendants are unaware of any decision ever finding Korea an inadequate forum by virtue of its discovery procedures. So that's basically how this entire document went. It's just a literal bomb being dropped on Nexon's argument. Awesome. Yeetus Surfetus. Heck yeah. Tell your friend that I'm honored and yeah, tell your friend that I'm honored. I'm a big old teddy bear. Did your friend see my feet pics? Yeah, and I'm married. Basically married. Technically, like legally, we're not married, but we've been together 10 years. We've been together and been together 10 years, lived together for 9. So like, the only reason why we're not common law married is because Oregon doesn't have common law marriage. The only reason why we're not legally married is because I don't like contracts. No, there's no common law in Oregon. Yeah, we're in Oregon. Yeah, there's no common law here. What up, Brian? Good. How are you doing? Is that BC? So there's like 4. So, OssePec. So the TLDR. So this right here. If you can see my cursor, this section, the line 26 at the end, footnote 4 is basically the best TLDR I could give of this. That statement is basically will tell you exactly how this entire summary or this entire document went. Iron Mace just completely shredded Nexon's entire argument in their last document. But yeah, everybody. So Brian here was in my New World company too. So for some of you, most of you guys don't know, but I ran a company of like 100 to 120 people in New World for like a little over a year. Sorry. I had to fix my tripod for like a year and a half. And BC was in there with us. BC is super chill. Heck yeah, George. Yeah, I'm like I'm outside of Portland. I used to live on like southeast 182nd out there, but we moved west because it was getting crazy out there. But yeah, so we just finished up reading this document. Um, I'm probably gonna play games for a little bit, and then if anybody has any questions, oh, here's another part that was a huge banger. Line 11. This is what I was looking for. Nexon's argument is the height of bad faith because Nexon has not even made a request for a document submission in the document submission order in the Korean litigation as to Iron Mace's source code. So essentially, in Korea, Nexon hasn't even asked the court to get the source code yet from Iron Mace yet. They've never even asked for it. So all of this bluster that Nexon has been saying, like they won't give us their source code, they won't give us their source code. Nexon hasn't even asked the courts to get it yet. So the third party investigation, so that article and the document, the court document that was speaking about the third party investigation, if Nexon didn't ask for that, the only other thing that I could think of is that Iron Mace is asking for it. Rust and Thistle. Yeah, there's a lot of cool places in Portland. There's a lot of cool places that have been shut down lately too, which sucks. COVID ruined a lot of awesome places. Um, but I mean, got to do what you got to do, right? Um, so does Nexon not asking for the source code confirm that Nexon believes the Korean court would get it? I honestly think that the only reason why Nexon hasn't asked for the source code is because that they're afraid that if they get the source code in Korea, this dismissal will go through. I think that if there's even a chance that they'll get the source code in Korea if Nexon asks for it, that this dismissal would fall apart immediately. I mean, the dismissal would go through like immediately. It would that would prove that Korea is an adequate jurisdiction to solve this case if they could get that going. But Nexon is like, no, we don't even want to ask for it because if they ask for it and they get it, they prove themselves wrong. If they don't even ask for it, if they don't even ask for it, Iron Mace throws that in their face, right? But being proved wrong, I mean, Nexon is just idiots, dude. Like either they're like gigabrain to the point where I have no like. It's entirely possible that they're like next dimension, you know, like not even talking about like 4D chess. We're talking about like 8D chess over here. Because like other lawyers I've talked to are like this entire thing is a stall tactic. A lot of it doesn't make sense. Um, Billable hours, right? Yeah, this whole thing is just to draw it out. Yeah, exactly. It's billable hours. They're trying to get a settlement. You don't do. Okay, this is going to be me getting a little bit serious. Everybody I've talked to that has anything to do with, like, I'm talking paralegals, lawyers, anybody who has anything to do with like actual court stuff, not like because I thought this was going to be a settlement case, just of my own opinion. But everybody I've talked to about this case that does, like, I know can confirm went to like either went to paralegal school or law school and passed the bar, and like can confirm that they have been lawyers, either were lawyers or still are lawyers, has basically said this is a settlement case from Nexon. They want to prove a point and they want to extract as much money as they can from Iron Mace. That's it. You don't hire who they hired or for a win. You just don't hire who they hired for a win. You hire who they hired for settlement. You don't do what their lawyers are doing right now to win the case. You do what their lawyers are doing right now to settle the case because it draws it out for so long that it bleeds Iron Mace dry. And Nexon can go billable hours. We don't like Nexon doesn't care if their lawyers are fleecing them by writing documents that are literally 4 times longer than they need to be, and just straight up like being misleading. Heck yeah, Brian, thank you. I appreciate it. Yeah, it's nice to see you on too, BC. That's rad. But yeah, you just don't do what they do So Nexon's rebuttal was that modern coding is mostly in English, and Iron Mace's, "Hey Bird, do you want to make your appearance? Do you want to show up today? You haven't been on today's stream yet." Yeah, come on. Hey, Bird. Cat cam. Oh, where are you going? You gonna type? Oh, you want to play with the straws? I see. You want to play with the straws and sit on stuff. Bird loves to put her butt on everything. She just goes around just putting her butt on stuff. Huh, Bird? What? Yeah. So this is a settlement case. And you know, this is for sure a settlement case, and Bird thinks so too. Did you hear that I was talking about Nexon versus Iron Mace? So you wanted to come see what was up? Yeah, good job, Bird. Good job, kitty. Good job, Bird. But yeah, you just don't do what they do unless you want to settle. And like they don't prove a point by winning; they prove a point by getting a shit ton of money for doing nothing, and making Iron Mace sign an NDA that says you can't talk about the settlement in the United States or Korea or anywhere globally. But yeah, the code. I was talking about the coding language. So Nexon said, we want to see the source code. Blah 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 blah. The whole argument was about the source code in their document. A lot of it had to do with they haven't gotten the source code from the court in Korea because they left out the part that they haven't asked for it, and that most of the documentation they want has to do with that source code, and that it's going to be in English. But what they leave out is that while the code is mostly in English, all of the notations and all of the secondary language is going to be in Korean, right? Just because the code language itself is mostly English or using English, lettering and language, all of the secondary stuff is going to be in Korean. How much do I honestly think they'll settle for? It'll be more than what they're asking for in court, in my opinion. So it'll probably be in the millions of dollars. Because if you really think about it, what they had almost 2 million unique subs in playtest 4. So if you do 2 million, and they want to charge up to $40. So if you do times $40, that's $80 million right there, right? So, and then if they charge 2 million times 30 is 2 million times, that's $60 million. Yeah, 60 million. So and that's just on release, right? So if they release to those type of numbers, to anywhere from 60 to $80 million, that's before any kind of skin sales. They haven't completely ruled out like battle passes that you could also earn in game, like either like a buy or earn through those in-game points that you could earn. They haven't ruled out some of that stuff. Thank you, PB and Jams. This is all thanks to Mike. This is thanks to Shanks. This is thanks to all the people that have been subbing on the Patreon and my YouTube membership and the Battle of the Andrews and everybody blank who's from one of my favorite. Who paid in the currency of one of my favorite countries, the Czech Republic, paid in Czech crowns. From everybody who's been giving me supers and joining the Discord and joining the Patreon and joining the YouTube memberships, like because of you, I bought a light. I bought the upgrade for my phone that allows me to stream in 4K. I got a new mic. I have a new mic stand on the way. I have a stand for my phone on the way, so it's not in front of my, because right now my camera is in front of the TV, or in front of my, well, technically it's a TV. My second monitor is a TV, and my phone is in front of that. So but yeah, all this stuff is yeah, it's from you guys. You guys got it all. This all is, you guys helped make it. I want to give you guys the best stream that you guys can have, that I can provide, with the most information I can provide, but I also want it to be, of good quality, right? Um, I want it to be, what the heck is going on with YouTube here? But yeah, this is all because of you guys. And this community of wonderful, amazing, generous, and kind people. Everybody who's been typing in the stream and dropping comments and stuff, like, you guys are all amazing people. Um, I haven't had to ban anybody ever. I've never banned anybody. I had over 100 people in here earlier, and I haven't had to ban anybody. There hasn't been any crazy doomers coming in here. Not a lot of trolls. This community is fucking amazing, and is really changing my life, and making it's just making me um, get excited about doing this type of stuff again, and it's reinvigorated my creativity. So yeah, thank you guys, for not only improving my stream and improving, making me want to make this type of content, but yeah, you guys are awesome. Um, but yeah, I also I wouldn't be opposed to cosmetics. Can't backseat legal doc reading, right? Yeah, they said that everything's going to be cosmetics basically, and then I think, as far as they can, said that they, if they do a battle pass, if I remember correctly, I might be misquoting them, but if I remember correctly, they said if they would do a battle pass, it would be something that you could earn from playing the game as well as just buying it. So buying it would just be a time saver instead of a pay to win, you know, which is not, in my opinion, is not inherently bad. Thank you, Austin. Love you too, man. Get some sleep. Yeah, get some sleep. Get to work tomorrow. Be well rested. It's important. Yeah, I think it would be cool if the cosmetics showed through the gear. If the gear went over the cosmetics, if that makes sense. If they didn't change the gear, but you could change the character underneath. I know that the elf had different stats, but it was still pretty well balanced. It was -1 dexterity, or -1 strength for +1 dexterity, you know, or yeah, the skeleton skin, stuff like that. If the skins were underneath the armor, but you could also earn those skins through points in game. You could earn those skins by being good. So if you're not good, you just buy the stuff, right? If you're good, you can earn it for free. If you're good or you play long enough, you get it for free. Yeah, I think there's been awesome. You know who I actually so I actually used to really like League of Legends battle passes before they changed them. You used to be able to earn or pay for battle passes with those blue tokens you can earn. But other than that, Riot's monetization is actually pretty decent in my opinion. They recently changed the battle passes to where you have to buy them and you can't really earn them. That's a lot of people are changing them to where you can't earn them in game anymore. But I think you should totally be able to earn them in game, and if you can, that's fine, as long as it doesn't give you a way to beat other people. Earning without pay, like WoW, or how Overwatch does. I've never played Deep Rock Galactic. Is it good? A lot of people have recommended it to me. Speaking of that, what should I play? We finished this. There's 3 more documents, but they're all I guess we could see how long the declarations are. Let me open them up. it's like 11:17. So yeah, I'll look at and see how long these um, declarations are. 1 of 10, so this one won't be too long. So this is the Declaration of John B. Duncan. So this is only 10 pages long. Oh, no, this is the one from, okay, so this is just the declaration. They're just citing the declaration in rebuttal to no, this is for the rebuttal of Jason Park, not Terrence. So I submit this declaration in rebuttal to the declaration of Jason Park. I am neither counsel for or related to nor employed by any of the parties, and I have no financial or other interest in this outcome of this litigation. I have personal knowledge of the facts set forth. Rock and Stone. Yeah, Dark and Darker is amazing. Oh, I've played Rocket League. Oh, I should play Rocket League right now. Yeah, I'm going to read this real quick. It's only like literally 2 pages. I submit this declaration in rebuttal to the declaration of Jason Park. I am neither counsel for, related to, or employed by any of the parties, and I have no financial or other interest in the outcome of this litigation. I have personal knowledge of the facts set forth in this declaration, and if called as a witness, I could and would testify competently to those facts. I am fluent in both English and Korean. I'm a native speaker of English, and I received my bachelor's of history from Korea University in Seoul, Korea, in 1972, where the language of instruction was Korean. I received my PhD in Korean history from the University of Washington in 1988. I helped create the Center for Korean Studies at UCLA in 1989 and served as its director beginning in 2001 until my retirement in 2019. During my teaching career, I taught advanced Korean at UCLA and guided graduate students in directed reading and Korean language sources. So this guy is the Korean master. I have translated numerous books and articles from Korean to English, and I have also written and published academic articles and written newspaper columns in Korean. I have served as a Korean language courtroom interpreter in Hawaii. So this guy is gnarly. And in Seattle, and I've provided consulting services on Korean language translation. Attached as Exhibit A is my abbreviated CV. I reviewed the declaration of Jason Park as well as 2 exhibits, references page 3, annual salary agreement and confirmation rights. The most accurate and natural translation of the phrase "whatever this is" relating to this agreement, with the word blah 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 blah. Nope. No way in hell. Meaning relating to. Mr. Park provides 4 possible translations to the phrase, but omits relating to the most accurate one. Of those 4 possible alternatives in connection with this agreement and regarding this agreement are reasonably accurate. However, arising out of this agreement is an unnatural translation and based upon this agreement even more so. There are 2 verbs commonly used for arising in Korean. One is whatever. I'm not going to even butcher that, which is a colloquial form and it's rarely used as legal terminology. The other more formal term commonly used in legal documents is whatever. Neither of those words is what is used in the forum selection clauses referenced in Mr. Park's declaration. I have seen contracts that use Korean phrasing that words, meaning arising in relation to, but that is not what is used here. I declare under penalty of perjury under the law of the United States that the foregoing is true and correct. So this guy just certified exactly what. Okay, so more facts. yeah. So this is somewhat so this is a verified court interpreter swearing under perjury that what Iron Mace said is true. Who's not paid by anybody. Sweet. See, this is a good example of why I like Iron Mace's lawyer. Because not only do they hire somebody, they not hire, but they just bring some random expert from the outside who just happens to be the ballerest of all ballers, apparently, on Korean language. Was the director for the director for the Center for Korean Studies at UCLA from 2001 to 2000 for 18 years, and also a teacher of Korean, came in and just validated their entire argument. And they did it in 2.5 pages. Like, they didn't have some dude who's not even a certified court translator, or it never has been, come in and try and certify their stuff. They just paid some guy who speaks Korean, or maybe not paid, but they just got some guy who speaks Korean to say what other statements could have possibly been relevant. And then they had them make up like a 10-page paper about the language of it. Just because there's more words doesn't make it any more true. And who are you going to believe? The director of the Center for Korean Studies for 18 years and a certified court translator, or some rando that speaks Korean? So yeah, like this type of stuff just leads me to believe Iron Mace more. You know, it just leads me to believe factual statements backed up by evidence, and factual statements backed up by experts with expert testimony, and these having experts who are also certified in the country you're certified in the country that you're operating in. You know, like, that's, you can't do anything more above board. Like, he's doing everything above board. He's making sure certified experts that have worked in the legal system are the ones doing their certification and making their declarations, instead of just like, I worked for Nexon and I speak Korean. You know, like, who cares what the dude who wrote the contract, or like the dude who now works in HR thinks? Like, I mean, I don't know who the declaration was from, but no, it was a non-certified transcriptionist. So who knows where that guy got his information from? But yeah, like, these guys are just way better. Is there anything else that's like quick and easy? Oh no, this is just supplemental declarations. Yeah, this is nothing. I'll read through it, and if there's anything in here, I'll do a live stream on it. But it's like 8 pages of like, here's where the case is. Yeah, we already know this. The location, yeah, it's in Seoul. We know. Oh, this is important. Hold on, let me. I'll download this real quick. Hold on, and I'll read that section. So this is a supplemental declaration from the lawyer, Iron Mace's lawyer in Korea. So this is going over. So this is This is their attorney from Korea. I'm an attorney duly licensed and practicing law in the Republic of Korea, and partnered with a law firm of Lin, L-I-N. I submit a declaration of support motion for dismiss. The location of the lawsuit, it's who filed it. So Iron Mace filed it against Nexon. Going over all that. Nerdy Man, what's up, dude? Welcome back. So who is Roxas? The expert basically said that. So Nexon originally claimed that the language of the contract could have meant like 4 different other things that it didn't mean. And the guy, like, one of the leading experts, a guy who sounds like one of the leading experts on the language of Korea in the United States, and who we know is a formally certified court translator, basically said that Nexon is lying. It's just making shit up. Is the gist of that document. That the former court translator, certified court translator, said that Nexon is making shit up. So, but here's what I wanted to read. Defendants have produced documents evidencing the creation of Dark and Darker. Iron Mace did not conceal any evidence. This is from the Korean attorney for Iron Mace. Iron Mace did not conceal any evidence regarding Dark and Darker and its creation in the Korean proceedings. Nexon's allegations to this effect in its opposition are untrue. If Iron Mace were to conceal such evidence in reliance to the KCPA, the Korean court would consider these circumstances when making factual determinations and render a judgment against Iron Mace in any way. The Korean Civil Procedures Act requires the applicant to make a request for evidence to the court. If the court finds the request is valid, it will issue a decision ordering the production of such requested evidence. However, Nexon has not filed any requests for evidence with the court in the pending injunction proceedings in Korean court. Under the KCPA, a party may request the production of evidence from another party by motion of the court. Nexon has not requested documents through this procedure. On the last day of the preliminary injunction trial, Nexon instead requested that the court close the preliminary injunction trial, arguing that the evidence submitted by Nexon alone proved Nexon's claims. In other words, Nexon took the position that it was not necessary to make an evidentiary request to decide the Korean preliminary injunction case. So Nexon didn't even give any information. They're like, nope, we gave you what we gave you. Make your decision. We don't want any more information. That's insane. Now Nexon argues that the Suwon Court District did not hear any testimony and did not allow it to cross-examine witnesses. However, a party's motion is required for the court to hear testimony and cross-examine witnesses, and Nexon did not make such a motion in court. Nexon didn't even cross-examine the witnesses. Any. According to this document. They didn't even hear any testimony. Nexon argues that Suwon Court District did not hear any testimony and did not allow it access to cross-examine witnesses, according to Nexon. However, a party's motion is required for the court to hear testimony and cross-examine witnesses, and Nexon did not make such a motion. This is really bad for Nexon. Really bad. They didn't even want to hear the testimony or cross-examine witnesses. That's like unheard of in the United States. Nexon also argues that the source code could not have been reviewed by the Suwon District Court because Iron Mace did not submit the source code to that court. Regarding such a claim, the following circumstances should be considered. First, the dispute in this case is not a case that involves the copyright of a computer program. It's not exactly. Unreal Engine is not in dispute here. Nexon is only claiming copyright infringement of the overall nature of the game itself, not the source code of the game program. If Nexon had claimed copyright infringement of the computer program source code, Iron Mace would have submitted the source code and requested an expert examination to compare Nexon's source code with Iron Mace's source code. However, Nexon was not willing to produce its own source code and did not allege any copyright infringement of the source code in motion for a preliminary injunction. So Nexon wouldn't give theirs up? So Iron Mace asked for the third party? So this basically confirms that Iron Mace asked for the third party investigation, and Nexon refused to give theirs up. However, Nexon was not willing to produce its own source code and did not allege any copyright infringement of source code. They didn't even allege any copyright infringement of source code. in its motion for a preliminary injunction. They didn't even say that the source code had anything to do with the copyright infringement. This is fucking insane. This is nutty. Oh shit, Nexon is so boned. Like, I'm getting overexcited here, but like, I need to have somebody look at this, like, immediately. My buddy Matt better like get back to me like now. He's gonna have like way too much shit to look at. Second, Nexon did not submit its source code to the court for comparison. Or Sean, he needs to get back to me too. There is no point in Iron Mace submitting its source code to the court of Nexon. Is not submitting its own source code for P3 game to the court. Okay, so once Nexon refused, Iron Mace was like, fuck it, I guess we're not going to give you ours either. Iron Mace will submit additional documents regarding the development of Dark and Darker to the Suwon District Court. Oh, so yeah, right here. Iron Mace will submit additional documentation regarding the development of Dark and Darker to the Suwon District Court. The Suwon District Court ordered the parties to submit necessary evidence by July 19th. And Iron Mace is preparing the necessary evidence accordingly. In light of these so they are giving their information. So Iron Mace is giving their shit, and Nexon's refusing. In light of these circumstances, Nexon's assertion that Iron Mace has not produced any Dark and Darker related development documents is completely misleading. This is insane. This is a banger. The KCPA provides various court procedures to ensure that the party's right to collect evidence is including application for witnesses. I'm just going to switch to this. There we go. Make this a little bit bigger so I can see what's going on. There we go. The KCPA provides various court procedures to ensure the party's right to collect evidence, including application for witnesses. And then they cite the Article 308 of the KCPA, appraisal, Article 333 of the KCPA, verification, Article. These guys are fucking awesome. This is amazing. Here. 1, 2, 3, 4, 5, 6, 7, 8, 9 articles. Here's 9 explicit laws of why we would have to give information. Request for documents, preservation of evidence, application for an order to produce documents, orders to produce final transaction information. I would like to explain Nexon's conduct with regard to the court procedures recognized under the KCPA in the application for preliminary injunction. Case filed in Suwon District Court, and the main lawsuit is filed in Seoul District Court as follows. Pre-suit evidence preservation. A party may apply to the court for evidence preservation. Then they cite the exact code of the law, even before filing a civil lawsuit to quickly secure necessary evidence. So they could get evidence before they even file for the suit to preserve evidence. Although it is possible to apply to the court for evidence preservation before or during the filing of a lawsuit for evidence, that must be secured on an urgent basis. Nexon has not utilized the evidence preservation procedure. Application for a document production under the KCPA. The KCPA provides for a document production order system, Article 345 of the KCPA, under which the court may order a party to produce a document in its possession upon application by other party. Furthermore, if the other party fails to produce the document despite the court order, the court may recognize the applicant's claim regarding the content of documentation as true. So this is bonkers, dude. This is straight up bonkers. So the common procedure in the Korean court is, if, say, I requested to see Nexon source code in Korean court, and then they fail to produce that document, the court's response is to automatically believe whatever I say, because they're not willing to give me the document. Korea does shit by the books. Like it's rules as written over there. It's not up to precedent. It's like rules as written. Here's the law. Here's all the articles. This is how it goes. So if Iron Mace is asked Nexon for their source code because Iron Mace says that it's different and Nexon still fails to produce their source code by the 19th, the courts automatically by law have to assume that Iron Mace is telling the truth. That's bonkers. That's nutty. Nexon has not filed an application for a document production order. Its application. They could. We don't know if Iron Mace has asked for Nexon's source code yet. We have no idea. But if Iron Mace asks for Nexon source code and is approved, if they get approved that if it gets approved as evidence, and Nexon, so if Iron Mace goes, hey Nexon, or hey court, we want to see Nexon source code for P3 and compare it to ours, and then the court goes, sure, here's the proper paperwork, and we will submit it to Nexon, and you'll get your paperwork. If they don't, whatever you're saying is true. Obviously. Yeah. Default judgment of the evidence. Furthermore, if the other party fails to produce documents despite the court's order, the court may recognize the applicant's claim regarding the content of the documents is true. Then they cite the exact code. Nexon is not filed for the application of the document production order. Application for appraisal under the KCPA. Appraisal procedure under the KCPA allows a third-party expert to compare the party source code to determine whether it is similar. Article 333 of the KCPA. However, during the 3 hearings for the preliminary injunction case, Nexon has never made an explicit request for examination of evidence, such as an application for appraisal, regarding whether the source code of P3 game and Dark and Darker game are substantially similar, the characteristics of the source code, etc. Nexon has not filed for an application for even an appraisal. So touch grass, in my opinion, Nexon will take all the L's ever. The only thing it's doing, so Nexon is probably like, we want $100 million. We'll settle for $100 million right now, or 50% of your profits. We want $100 million once you start selling the game, or we want 50% of the profits, or whatever. They're making some outrageous claim. And every time they take an L in court, like they're doing today, and if the case in the U.S. gets dismissed, all it's doing is lowering that 100 million or whatever they're asking for. So say it's even 10 million. So say it's 10 million. Each L lowers their ask by like $500,000, right? So every time they take an L in court, it's just lowering the amount that they're willing to settle for. So they're willing to take up to a certain amount of L's before they just like give their bottom line settlement. So they don't really give a shit because they have a number that they're willing to settle for, like right now. And they'll go below that if they think that it means risking losing entirely. Because at one point in time, the settlement will be cheaper than the lawsuit for both parties. It'll just be cheaper for everybody to settle. For the court, for Iron Mace, for Nexon, it'll be cheaper for everybody. At which point, usually people settle. In fact, only like 3 to like 20% of cases, depending on where they are and what type of case it is, make it to court, make it to trial at all. So usually, once it becomes cheaper for everybody to settle, they'll just pull the trigger on a settlement. However, those 3 to 10% go to trial because one person is very obviously winning, or because the case is dismissed it on, with prejudice or without prejudice. Sorry, my nose is getting a little itchy. My allergies are acting up. But yeah, so like it's like something like 3% of cases or 10% of cases get dismissed or something like that, like 3 to 10%, and then Like very few cases go to trial, and the ones who do are basically like guaranteed victories for one of the two parties. And if Iron Mace gets to the point where they are absolutely 100% sure that they're going to win, um, Nexon will just draw it out to make Iron Mace suffer, and Iron Mace will then fight the case because they know they'll win, and then they'll try to countersue probably, maybe. Well, so here's the reason, because even if Iron Mace wins, Nexon will still file an appeal. It costs a lot of money to win, and winning could be more expensive and lengthy. And then even if they win the first round, it might go to the higher up court. So it goes from a district court to like a regional court, and then to Supreme Court. Right? There's both Korea and the United States have a three-tier court system. So even if they win, it still can go to an appeal process, and the settlement will just straight up end it. And they can't and there's going to be an agreement in the contract saying that they cannot sue each other again for anything related to this. Yeah. So it's going to be it's just way easier for everybody to settle. Way easier. And at some point it's just going to be way more financially viable to settle for everybody. But this is insane. I can't believe. So Nexon's willing to take as many L's as they need to get money out of this. They don't care. This is like Iron Mace can come out tomorrow and say that we are never going to settle in an announcement, and I would still not believe that this will not end in settlement. I am like 100% convinced that this is going to end in settlement before November. Nobody can convince me otherwise. If it doesn't, I would be extremely, extremely shocked. So Dark and Darker game is arson. No, wait. No, I'm on 16 right here. Application for submission of materials under the Unfair Competition Prevention and Trade Secrets Protection Act, UCPA. The UCPA, which applies to the preliminary injunction in this case, has provision for submission of materials. They cite the code. This provision was introduced in consideration of the difficulty in calculating damages for trade secret infringement cases, and states that the court may, upon the request of either party, order the other party to submit materials necessary for the assessment of damages caused by infringement. Thus, a party to the suit may file an application for substantial range of documentation necessary for the calculation of damages. To date, Nexon has not filed such an application in the main lawsuit before the Seoul Central District Court. Sanctions for refusal to produce documents, if the other party fails to produce documents, despite a court order to do so, the court may recognize the applicant's claim regarding the content of documentation is true. Article 349. So Nexon could have easily gotten this information if they wanted it. Nexon easily could have gotten this information. In addition, if a party destroys a document that it is obliged to produce, or makes it unavailable for the purposes of preventing the other party from using it, the court may recognize the other party's assertions about the contents of the document as true. However, even if a requested document was destroyed, if it is recognized that there is a possibility that the destroyed part of the document contains content that is contrary to the residual part, and thus it is impossible to be certain that the purpose of the document as a whole is in accordance with the claim of the party submitting the document, the resulting disadvantage shall be attributed to the party who submitted in the destroyed document. And that's according to this Korean Supreme Court decision of this, rendered on November 17th, 2015. Request for forwarding the document of the KCPA has a document forwarding procedure that allows the court to request an investigative agency to forward documentation or documents in the agency's possession to the court. Article 352 of the KCPA. Nexon has filed criminal charges against Choi and Iron Mace, and the Korean law enforcement investigative agency has obtained a large number of documents and information through 2 searches and seizures of Iron Mace, Choi and Park. Under such circumstances, Nexon could have requested the court to order the production of these documents, but it did not do so. So Nexon has the files. They have the files because of the investigation. They could just go, "Hey, police, can we see the evidence from that investigation that we had you guys do?" And they haven't even done that. They haven't even asked for the information that they already have access to. So they don't even need to involve the court. They could just go to the police because of the criminal investigation. They already have the source code. The cops do. The cops already have all of the information. And Nexon hasn't even asked them for it. That's insane. I mean, settlement doesn't really matter about favor. It's just going to be, it's amount of how much Iron has. At this point, it's not about if Iron Mace will have to pay Nexon. It's about the amount of money Iron Mace is going to have to pay them. You know, I don't think Iron Mace was going to get anything out of Nexon. I think Iron Mace is going to owe Nexon a lot of money just to go away. Because Nexon could take the hit, right? Nexon could say, "We don't mind spending $10 million just to bury you." You know, just to because either way, if Iron Mace goes bankrupt, there goes a competitor. There goes a competitor. Because think about it, if Iron Mace wins this and gets the reputation globally of beating Nexon and producing banger video games, and then they get like $100 million in their first year for reinvestment, as well as being globally recognized as a company that produces banger video games, they're easily in contention for like the next up and coming Korean video game company. Because Dark and Darker is not only will not only be one of the best selling Korean games to come out of Korea in a long time, it'll be a better selling game in the United States market than anything Korea or anything Nexon has ever produced ever. Yeah, but it doesn't matter. So Brian, yeah, no, I get your point, Brian, but to me it doesn't really matter because Nexon has never produced a game that has been as successful as Dark and Darker in the U.S. Nexon's entire market relies on Nexon's entire market is reliant on Tencent because of China. The South Korean market, South Korea, Japan, and China are like their largest market, I believe. And most of their market is actually controlled by Tencent. No, not in the US. Maple Story was a huge game, but it was not nearly as big in the United States. This Dark and Darker would be so if Dark and Darker was owned by Nexon, it would be Nexon's single best US sales in their company history. US only. Just talking about US. Nexon has never really been able to break into the US and never gotten a really good foothold in the United States. Their main source of revenue is China, South Korea, and Southeast Asia. Yeah. But no matter how hard Nexon tries, they can't break into America. So that's the reason why they want to get rid of Iron Mace. Because Iron Mace has broken into the market that they've never been able to get into. So they want a piece of that pie. They want like a foothold into the United States. It's more about that. The money and their foothold into the United States through Iron Mace than anything else. So Nexon is willing to dump tens of millions of dollars into this if it helps destroy. Because if Nexon becomes one of the only like true Korean formed in Korea gaming companies that has a strong foothold in the United States, they have a very easy road to be pretty dominant in the Korean gaming market, even if the Koreans don't like them. But if they win out, I'm sure that public sentiment might flip. Right? If Nexon are proven to be a bunch of liars and cheats, and If they don't settle and Iron Mace wins, $30 to $40 for early access. They said 20 to 40, but I think it'll be probably closer to 40 for early access. Can start showing Iron Mace, the Korean law enforcement of it. So yeah, we read that. So they already have access to those files. Investigative agencies' obligation to cooperate. The KCPA stipulates that a person who has been entrusted with forwarding documents from the court must cooperate unless justifiable reason exists. Article 352-2 of the KCPA. According to investigative agencies actively cooperating with such requests from the court, send relevant documentation or documents to the court unless there are justifiable grounds, i.e., documents related to juvenile case or an individual's privacy. So yeah, they could have gotten all of this information from the police at any point in time. So yeah, let's get a switch. I mean, they could have gotten these files at any point in time. Gladly pay $100 for it, right? Requesting information provision, an information provision under the Copyright Act. Actually, hold on. I'm going to start off on 11 again. I'm going to take a quick 2-second break. I'm going to run and blow my nose because my allergies are kicking in. How do I mute this? Put a button under here. Oh, there we go. I'm an idiot. Hold on, guys. Have the mic upside down. I'll figure it out. So hold on one second. Testing, testing. You guys can hear me, right? That gain is super low. How's that? Is that better? I don't need AC anymore. It's not that hot. So that'll be a little bit better. Cool, and I could hear you guys through the monitor. Andrew, I added you as a friend. I added everybody who was waiting for me to accept. I see some messages coming through Discord. Yeah, I'm gonna finish this up, and then I'm gonna play some games, and then so I'll probably be streaming for like another half an hour, 45 minutes. I do want to finish up this document for everybody who's been watching. I know there's still like 70 people here. But yeah, I think they'll probably release somewhere between $20 and $40. In my opinion. Oh, you can hear the clickies. Maybe I should turn the. Am I too loud or is my gain good? This mic is way better though. So the motion for dismiss the motion did not go through. Have a good night, Andrew. Peace. Thank you for everything. Thank you so much for your support today and yesterday, and everybody. Thank you to the Andrews, all of the Andrews, Andrew Nation over here. Thank you, everybody. You guys are amazing. Yeah, for sure, Sebastian. Hit me up. You guys hit me up whenever. I'll be playing like as much as possible. If you guys don't mind me streaming when we play, um, I'm not like the best, but I just want to go have fun and murder people and kill skeletons and shit, you know. Um, so I left off at what 11? Requesting an information provision under the Copyright Act. The Copyright Act has established provisions for the provision of information that are intended to have similar effect to the discovery procedure under Rule 26B of the United States Federal Rules of Civil Procedure. That is, the Act stipulates as follows: where deemed necessary for collection or for collecting evidence upon request of the party concerned in a lawsuit against the infringement of copyright or other rights protected pursuant to this act. The court may order that other parties concerned to provide the following information that he or she holds or knows of the Copyright Act. This article is special provision in relation to the document production orders under this KCPA, specifying the scope of the document production and establishing sanctions for violation of the production order. Here, the scope of the information is very broad as it refers to 1. Information capable of identifying the act of infringement, or B, or a party related to the production and distribution of illegal copies, and or 2, information on the routes of production and distribution of illegal copies. However, the other party concerned may refuse to provide information regarding certain categories of information, such as trade secrets or information related to the production of privacy. So that means Nexon could withhold information because it might further the leak of trade secrets and copyright. However, they have every right to request information from the person they're accusing. They just can't ask Iron Mace for information that would then subject to them to possible trade secret harm, right? So Nexon could have actively utilized the provisions of Article 19 or 129-2 of the Copyright Act in a case seeking preliminary injunction against Iron Mace for copyright infringement, but it did not do so. Okay, I'm not going to go over the necessity for the case to be heard in Korean court because we've already went over that. But the evidentiary stuff is super important. So the UCPA Article 14-2 of the UCPA and Copyright Act Articles 125 whatever, provides strong protection for rights holders by having various damages estimation provisions that allow plaintiffs to estimate their damages, even in the cases where they cannot provide or prove actual damages. The USCPA or the UCPA also provides greater protection for trade secret holders by allowing the courts to increase damages up to 3 times the actual damages for willful infringement of trade secrets. That's nutty. So their deadline. This also has confirmed that the deadline in Korea for them to produce information is the 19th. So I doubt that we'll hear a decision back. It's possible, but I highly doubt we'll hear a decision back the same day. But it might happen shortly after, and they do have, I think, up to 30 days after that. My throat is getting super dry. My allergies are bugging me. Sorry. Get the whole guild to run bosses together? Hell yeah. Get like get like go. Will we all just freaking mob out and try to join up on the same level and just go and murder the boss? I've actually never been able to solo kill the cave troll. I've tried a bunch of times, I haven't been able to do it as a rogue. Cheaters, yeah, cheaters aren't a really huge thing. I'm gonna see if this has anything like up stump stumps really quick. Um, Litigating in the suit in the U.S. while all the witnesses are located in Korea would significantly delay court procedures. Furthermore, most of the physical evidence that the parties may produce is located in Korea, which makes it easier for Korean courts to examine the evidence. Oh, this line's pretty cool. Nexon did not fully utilize the evidence examination procedure granted by Korean law in the main lawsuit filed on August 20th, 2021. So the I keep hearing that from Korean people that apparently Nexon hasn't produced a lot of information or evidence against Mr. Choi in Korea. And apparently that's true because Nexon did not fully utilize the evidence examination procedure guaranteed by Korean law in the main lawsuit against Mr. Choi filed on August 20th, 2021. What up, Turbo Mouse? I heard Daniel. I heard once you get the timing of the troll, it's pretty easy. But yeah, I just never did it. I would always get like, I would try like 5 rounds in a row, and then I would just go back to murder hoboing. No, it's cool. Is that Russian, Turbo Mouse? What language is that? I tried to learn Russian for a little bit. There's a lot of Russian people where I live. A lot of Russian people. I wanted to go to Russia for a long time. See, I loved Goblin Caves, and I would try to kill the troll for like 5 runs in a row, and then I would just give up. I could kill like pretty much everybody in all of the bosses in the crypts, except for like in level 2. I don't think I've ever killed a level 2 boss either. Yeah, the caves rework looks dope. The hell rework looks dope. Um, so as well as a preliminary injunction case filed in Suwon District Court. This demonstrates that there was no necessity for Nexon to utilize the U.S. discovery procedure in this case. Nexon argued that the activities of Iron Mace, Choi, and Park for development of Dark and Darker game was sufficiently recognized as trade secret infringement, copyright infringement, and unfair competition, only with the evidence and documents submitted in the application for preliminary injunction, and requested the preliminary injunction case to be closed without filing any request for evidence, which is guaranteed by Korean law. This dispute occurred in Korea and is appropriate. Okay, yeah. This is nuts. So Nexon's taken a huge L. Like, this is a huge L for Nexon. This is just airing it out. All of this BS that Nexon is spouting about them not being able to get a hold of information is just blatantly lying. Like, I'm not even going to dance around it anymore. They're just blatantly lying at this point. Like, it wouldn't be called lying in court. Like, it's not perjury because they're just omitting truth. But like, in any kind of non-court situation, this would just be lying. And the only reason why it's not lying is because they're in court. That's nutty. That's nutty. But yeah, I think this is going to be the last document I read tonight. I've been reading for like 4 hours. Let's play some games. What do you guys want to play tonight? You guys want to jump into some more Halls of Torment? We could do here. I'll open up my games list and see what we got here. We got. I have Absolute Drift. I have the Angerfoot demo. Baldur's Gate 3. Cyberpunk. I would have to reinstall. Fallout 4. Halls of Torment. League of Legends. Rocket League, Neo Scavenger, Omega Strikers. I have Papers, Please. Pillars of Eternity 2, Deadfire, which is super good. Pillars of Eternity 1. Rocket League. I think there might be a Star Siege demo going on right now. Cycle Frontier, I'd have to re-download. And I do not have access to Wayfinder beta right now because it's closed. Let's play Dark and Darker, I wish. Low-key, I'm playing... What, you're playing Halls of Torment right now? Thanks, Enrico. Yeah, thanks for joining. Try Barony. I've heard good things about Barony. Let's do some Dark and Darker, I wish. But yeah, what do you guys want? Wait, what do you guys want to... What are you guys down for? I might just hop into Halls of Torment. Because that game freaking rules. My new game... So I started over for the stream. Go. Respond to some people on Discord real quick. Wake up and explain the docs at 6:30 p.m. last night. That's hilarious. Well, I guess last night. Yeah, for sure, dude. We're gonna play. For sure, hit me up whenever. If anybody wants to play games and shit together, like, just hit me up on Discord. I'm always down. The stream's going pretty good, Spivvy. I've been chilling for like 4 hours. I'm gonna play some Halls of Torment probably for like a half an hour. Have you guys seen Dangerfoot? Or not Dangerfoot, Angerfoot? Have you guys seen that game? It's a revolver game. So if you if you guys know revolver games, it's pretty. I haven't played the demo on my computer yet, but I played it at PAX, and I was hanging out with the revolver guys, and they let me play for like 3 hours. Like, have any of you guys played the Angerfoot demo? Because if not, like, I have to show you this game. It's hilarious. Angerfoot is hilarious. In fact, what I'll do is I could I'll just show you. I'll just show you guys Angerfoot. I got to make sure to turn the game volume down. It has some bangers. The game audio is Angerfoot. Angerfoot. So let me know if the game audio is too loud. It might be. I'm gonna have to turn it down a little bit because it gets bumping. It's hilarious. You kick people to death. I forgot how to kick. Why is there not? Why can't I hear anything? Can you guys hear the game? I can't hear anything. Yeah, I can't hear anything in the game. Odd. Damn it, the sound is like the best part of this. How do I pick it up? Play it on controller. Oh well. But it's like a fast-paced looter or fast-paced shooter, but you kick people to death. This game is insane, and it's all timed, so. Also, seizure warning, because this game has a lot of flashing lights. This is a game that I cannot let my girlfriend see me play. We'll go here. So that was the first level. I'm gonna plug my headphones into the actual audio jack. 1 second. That's not long enough. Here we go. game's hilarious. Game's so good. Was the audio a little bit better? I can't hear anything. Game's audio is too loud compared to my mic now. Okay, let me turn it down. So how about there? That'll probably be a little bit better. I cannot hear the game at all, so I'm going to try to do this again. 1 second, guys. Let's see. Can you guys hear me? There's dancing in the background? What the hell? Why can't I hear the game? Is that game? Can you guys hear me? Hold on 1 second. Game is here. We turn that up. Why can't I hear the game? I cannot hear the game through the mic. And my computer is not playing it either. Let me try this one more time. Odd. Sorry, guys. Sorry, guys. I know my stream, I was messing with it earlier, but I might have to do these headphones. Okay. Hell is going on here? What the hell? Okay, I don't know why it's... Weird. Something is interfering with the Bluetooth. Super weird. Oh well. Oh well. You know what? Fuck it. Fuck it. Janky headset time. I know this thing works. There we go. Okay. There we go. Can you guys hear me? Get wrecked. My name's Angerfoot. Eat it. Anybody home? Knock, knock. Give me your gun. Oh, I forgot you could kick people into each other. Fuck off. Dude, I'm almost dead. Or I was. There we go. This game rules. And the whole story is hilarious. The story is hilarious. Obviously, it's a devolver game or a revolver game. Fuck. There we go. Damn it. Oh, shit. The camera's not on me. Double kill. Fucking. Dude has a dong hanging out. Get wrecked, nerd. I ain't taking a chance. Fuck, I'm almost out of ammo. Fuck, why'd I kick that gun away? The freaking music in this game gets me. I had to listen to this for like literally 40 hours. It was actually kind of brutal at the end of the 40 hours. The fuck? That scared the shit out of me. Motherfuckers, dude. Fuck it. See ya. It's timed. That was nutty. Here we go. Hey, what's up, baby? Oh, hey. How you doing? How you doing, pretty lady? Stealing your wine. You want some? No, this is all mine. Angerfoot. You'll regret interfering with the crime gang. Check your fax machine. What up, baby? We have Arthur. He stole my shoes, dude? The dude stole my kicks. He's gonna kill my shoes, dude. That's it. Nobody fucks with the Angerfoot. Fuck! Or maybe they do. Come on in, dude. Give me that gun. Oh, fuck that. I like the way you move that feet. Angerfoot, dude, I played this game for like 3 fucking hours. Get the fuck over here. Come on in, boys. Ah, shit. Oh, shit. I murdered everybody. Fuck off. Get wrecked, kids. Oh, those guys. What were they doing in there? What were those two dudes? They're getting down? Are they getting down in there? Shit. Dum, dum, dum. So yeah, what do you guys think of Angerfoot so far? Trying to get my shoes back. Oh, fuck yeah. Oh shit! No, 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 no. Give me that. Hell yeah, one shot those guys. Get over here. I do not trust anything in this game. Oh shit. Fuck. So yeah, what do you guys think of Angerfoot? Can you guys hear me? Yeah, you guys, I think you guys can hear me. How's the mic sounding? And how's the game volume? Sweet. So now you guys have seen Angerfoot. I actually really like this game. But I think I do want to play. I'm kind of addicted to Halls of Torment right now. So I'm gonna play some. I'm gonna do that because I love Halls of Torment. Halls of Torment. There we go. And then I'll move this down here. There we go. Yeah, it's basically like first-person Hotline Miami. 3D first-person Hotline Miami. It's great. I love it. But I only have the demo right now, and I don't want to spoil it before it comes out. It should be coming out like early next year, I think. But let me go back to that. There we go. You're playing as the Archer right now. Gotta mess with this. There we go. So who should I play? Crossplay? Wait, crossplay in Halls of Torment? What up, Bjorn? We're just chilling, playing some Halls of Torment right now. I'm gonna play the Exterminator. And I'm gonna see if there's anything good. Oh. I don't have nearly enough for that. I do have enough for that, though. Don't care about crit chance. I will keep that. I will take this, and then that. Let's go. Let's try to beat the Ember Grounds. I haven't beaten it on this one yet. Yeah, I'll go through the second map right now. So I've already cleared. So damage for sure. So I'm gonna rush to try to get the fire breath, because I'm gonna try to go for full fire damage right now on the flamethrower guy. So there is a trick to beating the first boss, and there's a trick to beating the second boss. There's a way to cheese the first boss, actually. I haven't made a video on it, but I can show you guys how to cheese the first boss. I'm going to do 40% pickup range, because I'm going to level up quick. Because I'm going to try to show you guys a flamethrower cheesy mode. It's I call it the walk forward method of victory. 6% movement speed. You tried doing flame loadout? Yeah, it's not too bad. It works really well on large troops and just like essentially walking forward, like I said. But you got to try. The key is to rush the flame breath as early as possible. I haven't unlocked I'll get the rain for sure. No! I'm gonna take Phantom Needles. just because it's 360 degrees out the gate. So now I'm kind of forced to go get the other one as quickly as possible. Damage, of course. The flame breath. So if you look at his crit chance, his crit bonus is 28%, but that's just because I have these. I have this on. So it's standard of 20 of. So I have a 40% increased critical damage. But he has a 0% crit chance. So getting crit chance on him isn't really. It can be beneficial, but since he does magical damage anyway, it's kind of a waste unless it's like, unless you're getting something that's weak, right? So, like this, I wouldn't get. So I'd do either movement speed or I'd get phantom. So I'm gonna do phantom needles. So it's like one of the last things you upgrade is crit. And crit damage and crit chance. You go straight for damage, and you want to upgrade your abilities on this guy as fast as possible. I'm going to get movement speed. So this guy you can kind of cheese too, just by walking around him. Because he throws the fire orbs like directly in front of him. Yeah, Phantom, I think it's just called like the Survivors genre. This one's like Diablo 1 meets Vampire Survivors. It's pretty good. Yeah, the 10 plus 10 base damage helps a lot. So like this is kind of a shitty roll. So I'm just going to take regeneration. Because you can play the Exterminator as kind of like a mini tank through base defense. His block is super weak, but his primary thing is just raw damage and attack speed. And then you want to get his cone and range up as high as possible. Is like the real key. Because he has like one of the best wave clears in the game. So, and I, like, people who watch me play, I do a lot of early game pickup range. And especially since, did I wear that amulet? No, I did not. I can't buy it yet. So I'll do regeneration just because crit damage is useless because I have 0% crit chance. Base health. So like even if you get hit with him, you should have a large enough health pool by the end of the game, and you should have enough damage to kill shit. But even if you get hit, they should be doing very little damage, and your health pool should be high because you have a lot of stuff you don't have to pick from. I'm actually gonna do attacks, just regular attack speed, because I want to increase the attack speed for my. There we go. Let's see if I get the flamethrower. No, fuck. I'm not going to be doing, so I guess I want magic damage. Just raw damage for sure. What do I have to get for the flamethrower? Do I have to take the fire damage? I'm gonna do this. Maybe I'll just upgrade my needles instead of going the flame damage. It's kind of a weak move on the Exterminator, but it's okay. Because here we go. Oh fuck! I need multi-hit. So I'm just gonna level up for a while and just come on clear. 20% range. I'm not gonna level up my lightning at all, probably. Here we go. Burn chance. I think once I get burn chance up high enough, I can get fire breath. I might be able to do it already. Is Dad good? Yeah, Dad's good. I love Dad. And Iron Mace is like honestly laying the smackdown on Nexon, to be perfectly honest. Dedication. So the reason why I do pickup range is because it lowers the reliance on magnets. And okay, so this is where I start getting my wider cone. Because the wider cone and longer range is huge on this. It also affects the stun range and the what's it called? It affects the lightning. So I'm gonna do pickup range so I don't miss experience, and I increase my level up speed, especially since I have the amulet that does the experience bonus. This amulet is super good, 50% experience. Like, you can turn off the auto attack on this. I'll do this so I can upgrade my needles. Projectile range for sure. I need that flame breath, so I'm gonna wait until I have a few levels. And burn chance, there we go. Maybe like one more level in burn chance. I might be able to guarantee I'll at least be able to get either upgrade my needles or get the dragon breath. Range. Don't care about lightning. Hey, I have a flamethrower too, sucka. Think you're cool with your little flamethrower? One thing I do is I like to play around these rocks. Shit. Oh, that's a shirt I don't have yet. What is it? 3% chance to give you 1 hit point. Yeah, it's pretty good. I'm gonna go drop this off in the well after I clear this wave. The movement speed. But yeah, I don't really do crit chance until the end. Iron Mace is the GOAT, basically. So, if you missed the update on the document, essentially, huge Iron Mace W makes me my so my initial estimation was that Dark and Darker, or the case dismissal, probably has like a 10% chance of going it through. I think I'm officially going to raise that to like a 20% chance of going through because of this document alone. Just because it was so filled with evidence and actual like case files and like citing actual legal precedent versus like direct out of the law, not just like court cases that they're not citing. They cited court cases specifically, but they also cited like DMCA law and like federal laws. So it's pretty huge case, or pretty huge document. At least in my opinion, it was pretty good. I would give some of that stuff a definite read through. I need slightly better pickup range. I like my pickup range to be just larger than my attack range. Burn 10,000 enemies? Hell yes. Die! 8% attack speed, please. Oops, didn't mean to do that. Range. I'm gonna go over and get that. Oh no, wait, he'll drop one. Wave clear on Exterminator is just massive. Just literally point in a direction because it doesn't get stopped like the arrows do. 10% damage, please. Ouch, 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 ouch. But see how I'm like barely taking any damage because he has high defense? And I have 730 hit points, so it's like not a big deal if I get hit a few times. Piercing? It's not super important on him, but whatever. If you notice, my attacks aren't getting blocked a lot. Count size. There we go. Damn it! Which one should I take? If critical hits, split needles into 2 new projectiles. Both new projectiles as strong as original, increase base damage by 15, or the... Should I take Phantom Rift? If needles could still hit more enemies with the maximum range is reached, they deal their remaining damage as magic damage in an area around them. Which one should I take? 2 or 3? I've never taken Phantom Split, so I'm gonna do it. Oh, but wait, I can't critical hit. Damn it. That was a waste. Oh well, at least it does more damage. It'll crit later. Kind of a shitty roll. Count size. I'm gonna do Metabolism because I want my health to regen faster. And I still have the magnet, so... Oh, never mind, I just got one. Range. There we go, weapon damage. I'm gonna hopefully I can get the freaking... There we go. Time for victory. Uh, 10 base damage, yes please. So how are you doing, Bjorn? How's everybody doing tonight? That was late. Oh shit, I got stuck on the rock. None of these are good. Fuck it. Oh, I'm already at worms? Good rock. Yeah, I think slimes are my least favorite. Worms are my second least favorite. Ooh, 5 base defense. So even if I get hit, I don't take much damage. My damage is going to drop off a little bit though. Can't block a flamethrower, stupids. Oh, that guy actually did block a flamethrower. So maybe piercing does do something. Reinstalling Battle for Middle-earth. Is that any good? I haven't played too many of the Lord of the Rings games, even though I love, love, love Lord of the Rings. I'll do damage instead of attack speed. I used to be like obsessed with The Hobbit and Lord of the Rings when I was a kid. Love those books. When my mom got me, I think I was in like high school or some shit. My mom got me Harry Potter because everybody was reading them, and I was like, I don't want to read these kids' books because I'd already read Lord of the Rings and shit. Started reading Harry Potter and was like, these are kids' books compared to Tolkien. Told my girlfriend that she loves Harry Potter. One of the best strategy games ever made, really? So, Vexed, yes. We had some port documentation drop for Dark and Darker. I read it live on stream. I'm just going to copy those excerpts into a document and just kind of give that as a TLDR. Maybe I'll leave it as a post. And because Iron Mace clowned on Nexon today. Like, just straight up clowned on Nexon. I need to get my Fire Breath to level 3. Yeah, not a lot of people do any. Everybody goes glass cannon in these games, but I don't think they realize how good metabolism is once you get it hot, like high enough, and especially like base defense. Realistically, block is super good too. Range is for sure it. Because there are builds in this game that make you basically invincible. If your base defense and your block is high enough, you like don't even need regeneration because you just don't take any damage. Like you never take damage. Oh, stupid rock. No, 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 no. Please be something good. Transform the damage type of your main weapon into fire? I already have that, but plus 15 burn chance is good. Leave a trail of goo. Oh, I think these are good. When you do not use your main attack for 2 seconds, your abilities become stronger over time. This is super good for, I think it's the Warlock? But I am going to take this, because I like it, and it's probably not going to get carried over anyway. So it doesn't really matter. And I can replace this. Because I don't have crit anyway. So give me fire damage. Ow. Ow. Cone size, please. Have I leveled the fire thing up enough? Have I leveled it up at all? I have not. Blast cane is the only option. You can't die if you don't get hit, right? And if everything's dead, they can't hit you. I mean, it makes sense to me. The math works out. There we go. Need that. Big number make brain happy. Big number equals better, right? Damage. I mean, you always want to take damage if it's available. Unless there's like something that is just going to equate to more damage than the 10%, like take that. But if damage is available, you take it on like every class. The only class I haven't played yet is the Shield Maiden. I had her, but I never really played it. This is my second or third run through. I've started like once or twice because I just wanted to start over for stream. But yeah, Iron Mace laid a big old they just completely destroyed Nexon today, as far as I'm concerned. It like doubled their chances to get the dismissal as I see it. Oh, there we go. Now I can do this. Damn it. Oh well. So their chances went from like 10 to 25%. Like 10 to 20, 25%. Dismissals just aren't very common to begin with, but this has a higher chance than most dismissals just because everything just seems to be falling into place. And Iron Mace's lawyers are just super good. Maybe I'll just level this up to 6. can. Yeah, I mean, I haven't really gotten hit in a while, and my life is almost back up to full because of the regeneration. And I haven't gotten really any health. There's 5. Oh, fucker. Oh, I got a bunch of shit. A bunch of pots. Full health. Not potion. Shit. These all suck. For where I'm at right now. Those mobs look like cinnamon rolls? Didn't know those were going to be so dangerous. Right? Okay, now I should be able to level this up. There we go. Knockback. Thank you very much. I guess. Not really much else. I don't really care about movement speed. I don't want to outpace my Dragon's Breath by too much because then it won't be useful. I'll have to slow walk forward. Base defense. I don't want to take any damage. Yeah, basically once you get the knockback, you just kind of follow the Dragon's Breath because it just pushes everything back. I need a magnet. Where are all of my magnets, please? I don't want to get that one yet. I'll save that for the boss. There we go. Deal 3 million. I did it. 500,000 enemies with damage effects. And this is why I like this, because it works against slimes. And I hate slimes. Die, you stupid cinnamon rolls. Ow, shit. The worms, too. I have, like, the purple stuff, like, blends into the background for me for some reason. Oh. Worm boss. I got shit on me. This isn't Tremors. I ain't afraid of you. Oh shit. I have no idea what that purple potion does. I've never bothered to read it. Ow. Stupid worm mom. Hey, I've done 1 million damage with Dragon's Breath already. This is the last one I got, too. Ow. Fuck off. Get wrecked. I don't have this one. I don't know how much longer I have until the final boss. So I usually save one magnet until after the final boss, then I'll go run and grab it so I can get all the rest of the experience and money and whatever. Attack speed, please. I will walk this way, very slowly. You shall all die! Fuck. There we go. I need to not get hit for a little while. Gotta stop being in the dirt. Oh, hey, bird. I'm like in the zone here. Good. 20% attack speed's actually pretty good for this, especially since my attack speed's already so high. The reason why I don't like the slimes is because they get like some kind of like a iframe when they split up. So you could do like 1 billion damage to them, and as long as they're like in the animation for like breaking into 1 million pieces, in their split animation, you can't hurt them. Oh, hey, bird. Here, you want to be on? Nope. You want to mess with my straw? What do I want to pick? Bird, you're putting your butt on my monitor here. What do I pick here? I have no idea. Pick base health. Give me all this sweet, juicy EXP. Ow, fucker. Oh, hell yeah. I love that shield potion. Those needles scale super well with attack speed. Just straight up attack speed damage. Any second now. What the hell is hitting me so much? What is breaking through my fire breath? So does crit chance even work on? Yeah, but I only have 10%, and I've gotten like 4 crit chance upgrades. There we go. So the key to victory with this guy is literally just kiting him. And staying out of those things. Those things are going to be the most dangerous. So you want to kind of kite him in a right direction. So like, you want to go left when you see those things. The circle things. But I'm just going to go run and get the magnet. And catch all these orbs on fire, because screw it. And here's also one reason why I wanted the fire breath. That's because it pushes the orbs back. So you want to circle him in a counterclockwise, because his fireball only goes in a clockwise direction, and so with the fireballs you want to go counterclockwise, and then with the little whirl of death, the blade thing, you want to go clockwise. Basically just follow that, and then just avoid these little guys. There we go. I'm gonna upgrade this. This. Nope. Thought that was fireballs. So as soon as you see fireballs, you move right. And then as soon as you see the little whirly blade thing, you can just literally back up and it'll miss you. And then you just do this forever, really. There is like a trick to killing him, but I don't know exactly what it is. There's like a way to beat him quick. One Pig's videos? I like One Pig. I think he could do a little bit better research, but I really do like One Pig. I think for like, because most of his information comes from like what I did tonight, right? He basically does what I did tonight and then has his editor clip it into a video and then releases a video. I like the difference between him and me is like I'll go take what I've read, give it to somebody else, have it like my opinions verified or like denied, you know, and then try to talk to as many experts as possible, which is why my videos take like days to come out and his are like immediate. But for getting easy and like I guess, fast information and easy to digest, I think he's great. And his opinions usually aren't too far off of the truth. It's just like, he's right. I would say he's right more often than he's wrong. But he does lean into a little bit of hype and speculation more than I think he should. But other than that, yeah, I like him a lot. Seems like a really good dude too, so as far as I can tell. So yeah, nothing against good old One Peg. I wouldn't cite him as an expert for anything, you know? I mean, hell, I wouldn't cite myself as an expert for pretty much anything. Except for, like, marketing and writing books. And science. Some science stuff, but I'm so out of practice with most math and science that that's laughable. I'm not following my own advice. Yeah, I mean, he really likes he seems to really like Iron Mason Dark and Darker, and he wants them to win, and I hate when this happens. Sorry. He wants them to win, and he's he's entitled to his opinions. And I don't think people should hate. I saw a lot of people giving him hate for being wrong a few times. And it's like, he's just giving his opinions, dude. We're allowed to be wrong. Our opinions are going to be wrong. I've been wrong on a few occasions, and, I think the major difference is, like, if you're wrong, you should correct yourself. And admit that you're wrong and learn from it and grow. And if you don't do that, then there's an issue. But, yeah, there's no reason for anybody to hate on One Peg, I don't think, in my opinion. And if he, misspoke or was wrong about a few things, or if he had some weird takes, who cares? Everybody has odd takes. Not everybody's going to agree with me. My opinions are going to be wrong every now and then. As long as we all grow and learn from our mistakes, there's nothing wrong with it. Nobody's going to be perfect, always. Making mistakes, in my opinion, is the most human thing we can do. Yeah, he's doing the same thing most YouTubers are, including myself. Just trying to get their content out there and talking to people and trying to be chill. I don't think there are some people that come in on the YouTube with malicious intent and try to purposely mislead people, but he's definitely not that. Not by any stretch of the imagination. So when this happens, you just got to kind of start popping them, and he'll make new ones. You gotta start popping these little nut sacks. Or you do this. Just run away. Dodge the nutsacks. And then find them out in the open. Oh wow, shit. My flame breath blocked that. I couldn't see. He's almost dead. So yeah, I'm gonna blow some of these guys up. And try to make him appear somewhere over here. Of course, he appears where I don't want him to. Yeah, I have. I can do another one for you though, Jordy. If you haven't heard what the documents were about, I'll give you another TLDR. I'll pop them open before I head off stream, and I'll just do a quick TLDR for everybody who just got here late. I know there's probably some people from Europe logging in, and other, you know, everywhere else. Oh shit! I did a lot of quests. But yeah, that's how you kill the second boss. Got him. And I made a bunch of money, so now I can buy this. The best. What else do I need? Elven slippers are good. Echo band is pretty good too. Yeah, I'll do that. Buy those two. And then I'm going to upgrade my fire damage twice. Just because I can. So, yeah, I will go over the... I'm going to make a video about this tomorrow. For sure. Like, 100% about the last two videos. And I'm going to kind of compare... about the last two documents and kind of compare and contrast. And see how this all plays out. As well as, like, my phone call with the court administrator. But, so, the TLDR is... Let me open up the document real quick. So, the supplemental declaration is actually what I would kind of go to for a quick summary. So, let me go to all the bolded stuff. So if you want to know how today went, it's basically there was two massive documents dropped that completely proved that Nexon is basically lying through their teeth. That's the wrong one. Yeah, isn't it this one? No, it's the defendant's reply. Once I find it, I'll switch it over. There we go. Um, there we go. Oops. And I'll make this bigger. There we go. So the TLDR is so I'm gonna do a quick TLDR and then I'm probably gonna hop off for the night. I've been streaming for like 6 hours, I think, close to it. Read through a bunch of documentation tonight, so I hope you guys all enjoyed the stream. Um, Thank you guys all for your support. Like I can't even express my gratitude. Um, I mean, this mic right here, my new mic, is because of you guys. Um, I got a new light up there because of you guys. My cat loves you guys. I can't express my gratitude enough. You guys are making this all possible. You guys have upgraded my stream already. You know, in a crazy amount. I have new in-ear monitors coming on Sunday because these ones literally just broke on stream today. Um, but yeah, thank you guys. Thanks to everybody. Thank you for everybody who's joined. You know, all the new members that joined today. Everybody who got supers. Like you guys are all crazy, and I love you guys so much. The amount of support and generosity and kindness that you guys have shown is truly incredible. I broke over 100. I think I like almost got to 110 concurrent viewers today. That's incredible, especially on like for a smaller streamer on YouTube, or for like a smaller streamer and smaller content creator on YouTube. That's incredible. Um, that's an insane amount of live views. So yeah, you know, I can't thank you guys enough. So I'm gonna read some stuff that kind of sums up how tonight went. Um, and one of those things is right here in the defendant's reply that was put out. You could find these for free on Court Listener. I'm gonna have them up on my Patreon as well for free. Um, I post all of my court documents on my Patreon for free as soon as I get them. Um, so yeah, the first thing that kind of gives a good example of what happened tonight, what this document is about. It's Iron Mace's rebuttal to Nexon's opposition of the dismissal, which is kind of a confusing sentence, but so Nexon opposed the dismissal that Iron Mace put forward, and this is Iron Mace's opposition to their opposition. I guess is the easiest way to say it. So the argument does not pass superficial scrutiny. If Nexon believed that Korea cannot provide any remedy for a claim of copyright infringement, why did it sue Iron Mace there? Which is hilarious. So why if Nexon does not think that Korea is a valid valid venue for their lawsuit, why are they suing Iron Mace there? And then they go on to say defendants are unaware of any decision ever finding Korea as an inadequate form by virtue of discovery procedures. So there, as far as Iron Mace is aware of, there's never been any decision that has ever found Korea as an inadequate forum for some kind of copyright dispute or for discovery procedures. So they have a pretty solid grounds to sue them from. And then there's another statement down here, I believe, that states that the reason why they didn't post the playtest 5 in Korea, it was actually because they lost their consumer rating on Steam. So Steam was actually their source of their consumer rating, and they can't actually publish in Korea without that consumer rating in place. Korea won't recognize a former consumer rating. It has to be active, is what it sounds like. Um, so like movies get rated R, you know, games get rated E through T for teen or whatever. Peggy 7, whatever the heck those things are. So they couldn't release in Korea. Like Nexon made the argument that all of the business they're doing is in the U.S. and they're specifically targeting the U.S. and that they're actually specifically not targeting Korea on purpose. But the only reason why they couldn't release in Korea was because they got the DMCA and that they're not on Steam, so the Steam verification isn't valid. So that's some like two of the biggest ones from this. There's also another one that's in bold in this that's pretty huge. I can't remember, but then there's also a short document called the supplemental. It's from Iron Mace's lawyers. That goes over. So this is Iron Mace's lawyer in Korea. He gave a. Sorry, it's 80 degrees in here now again. I turned the AC off. So their lawyer from Korea gave a bunch of information as well. And sorry if it gets a little noisy, but it's like 80 in here again. So what this document basically says that Nexon has actually never even asked either the courts for the source code. They've never asked the courts for the source code, and they have every right to. And they name like literally 9 laws that say that they have every right to ask for the source code from the courts, and they have never asked. And to add to this, if everybody remembers back when the investigation happened, when Iron Mace got raided, apparently the police took their source code and all of their files and copied it and put it into evidence. And Nexon has had, all they have to do is request it from the police. And they've had access to it through the police this entire time. And they've had access to it for like 2 years because they had a lawsuit against Mr. Choi. So they've had all this information for like 2 years and they've never asked for it, ever. And to be more specific, they were somewhere down that. Yeah, however, Nexon was not willing to produce its own source code and did not allege any copyright infringement of source code in its motion for preliminary injunction. So they're not even alleging that they copied any source code in Korea. So Nexon isn't even accusing them of copying any kind of source code at all in Korea. Second, Nexon did not submit its own source code to the court for comparison. So they're not even willing to submit P3 source code. There is no point in Iron Mace submitting its source code if Nexon is not submitting its own. So, Iron Mace, and then it goes on to say that Iron Mace will submit additional documents regarding the development of Dark and Darker to the Suwon District Court, and the Suwon District Court ordered the parties to submit necessary evidence by July 19th. So Iron Mace is planning on turning this information in by July 19th, which is the deadline for their investigation. So, yeah, I mean, that's pretty much really it, other than like, here's like literally nine articles of law in Korea that Nexon's or Iron Mace's lawyers cite about how easy it would be for Nexon to get information about their source code, because it's all available through the courts or through the police, either way. But there's also something towards the end. So here we go. However, during the 3 hearings for the preliminary injunction case, Nexon has never made an explicit request for examination of evidence, such as an application for appraisal regarding whether the source code of P3 game and Darker game are substantially similar. So they've never ever asked the court to do a comparison for Darker and P3. So after reading this, my chance went from like 10% to like 20 to 25%. Like it doubled, just straight up. Like this was a huge, in my opinion, this is what they call the proverbial smoking gun. especially for dismissal. Like as far as evidence for the dismissal case, this is like a smoking gun. It's huge. If you haven't read it, I would highly recommend reading at least the supplemental declaration of Yoon Jun Jong, because it has a lot of information about Korea in it. So if you're interested in Korea, the Korean cases at all, definitely read this whole thing. And I have to stress that he's saying this under threat of perjury in the United States. So if he is lying, Korea will extradite this guy, or Korea will disbar this guy, so he won't be able to practice law in Korea, and he could be sent to the United States to be arrested for committing perjury. So like he's not lying. There's like a 90% chance that he's not intentionally lying on this form. But yeah, again, thank you guys. It's almost 2:00. I've been streaming since 7:47 p.m. I keep my percentages and stuff low intentionally, but yeah, thank you everybody. Nerdy Man, thanks for showing back up. Not Too Shoddy, thanks for showing up. Bjorn, thanks for showing up. Everybody who did the super chats and is helping me amp up my stream. I got 4K video now through my phone, or I should. I got the light. I got a new mic. I already have a mic stand on the way and a camera stand for my phone. Upgraded the background if you guys could see the artwork and stuff. So I really want to put as much. I want to put as much effort and bringing you guys quality content as possible. So if you guys have any ideas for the streams, for games you guys want me to play, for any news you guys want me to cover, if there's anything you think I've missed or covered incorrectly, please let me know. My goal is to help this community grow. My goal is to fact find as much as possible for this case. And even after this case is over, I want to provide nothing but quality information and quality build guides and quality entertainment. I want to bring value to your guys' day, because you guys have changed my life already, and you guys are changing my life every single day. You guys join the stream and help support me in this channel and this community. So I want to provide you guys with as much value as possible, because your time is important. Your energy is important. Your time is important. Your attention is important. So yeah, A. Larson, I'm going to be doing videos tomorrow. I'll be making a video on these for sure. On this, my phone call with the court administration, and then the court administrator, and then the article from Nexon. I'm going to do like a short recap of what happened in the Nexon article, and then I'm going to do all the rebuttals from Iron Mace. So yeah, hopefully it's going to be like under 30 minutes. I'm trying to button them up and be a little bit more concise, but there will be a TLDR in that, as always. But yeah, thanks to everybody who's watched. I'm going to be out of here in a minute, but if anybody has any questions before I go, please hit me up. Do not hesitate to add me on Discord. Join the Discord. I have a link in my bio or in the description of the video. But yeah, guys, thanks so much. Peace.